have to fix my chair. Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Ariane Vuono. To my left is Justice Eric Neyman. We are the judges that will be hearing the 6 cases that are on the list today. I know that many of you have been here before, but I just want to go over a couple of ground rules. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all your materials, so I suggest that you get right to your arguments. I know there are a number of observers in the courtroom today and that the Chief Court Officer has spoken with you. I don't expect any problems, but the court officers are instructed that our rules apply, and if someone has to be asked to leave the courtroom, you do not need my permission, please do that. Some of the cases are impounded or partially impounded, and I will make that announcement at the time that I call each case. With that, we will start with our first case of the day, Commonwealth versus Shannon POLACKE. I apologize if I've mispronounced that. Docket number 24P1020. This case is partially impounded, so please do not use any victim or witness names. Counsel, when you're ready.
Thank you, Your Honor. And you pronounced it perfectly.
Thank you.
If it please the court, Kirsten O'Brien on behalf of Shannon POLACKE. Good morning.
Good morning.
I'd like to start with what I believe is my stronger argument, which is the argument regarding fresh complaint testimony. The Commonwealth argues...
That's interesting to me that you think that's your strongest.
Well, then I will retract.
Well, no, I guess my question really is, I don't think anyone saw it coming. I think that's fair. It came out on cross. I can't imagine that trial counsel saw that coming. But it seems to me that he did a pretty good job of using it both in cross and in closing. I candidly thought the prior bad act issues were the stronger issues. So tell me why you think the fresh complaint or the first complaint is stronger.
So I would respectfully disagree in that I don't think trial counsel made a sufficient, took sufficient measures to remedy what had occurred and what was now before the jury. We have, as we see in the case of Commonwealth v. King, we have rules about whether fresh complaint testimony can be raised if there is no actual fresh complaint witness that the Commonwealth intends to offer. And there's a reason for that, and that's because this type of testimony is incredibly important, particularly in cases like this one, where there is a case regarding delayed disclosure in a sexual assault. The timing of that disclosure is incredibly important, and often, by the very nature that it's a delayed disclosure.
But how do we discern on this record whether there's prejudice? So as I understand it, the witness said in 2017 she told her stepmother. Defense counsel then used that in closing argument to say she allegedly disclosed it in 2017, but there's no disclosure until 2021 to the police. And that doesn't make sense, at least that's the argument. And you also have the fact that here, at least my understanding is the stepmother did not testify. If she had, that might make it a different analysis. But how do we make the determination of prejudice without a motion for new trial and without hearing from counsel whether or not that was a strategic decision?
So that was a couple of questions, and I'll answer your last one
That
first.
was a long, poorly phrased question.
It was not.
So let me ask it this way. How do we discern on this record that there was prejudice without a motion for a new trial?
So I would say that in regards to the argument of the necessity of a motion for new trial, my position is that trial counsel's failure to really make any remedy for this was because exactly, as Your Honor noted, he was caught off guard. I don't think anyone saw this coming. The problem is we can't tell because the jury never heard whether the victim actually made this disclosure to her stepmother or not. Now, it appears from the record, it's very clear from the record, that the Commonwealth certainly thought she never had. So my position is perhaps the most effective remedy would have been to say to the judge, I am looking for a stipulation from the Commonwealth that this is the first time, as she sits on this stand today, this is the first time she has ever mentioned to anyone that she disclosed this to her stepmother.
How could you have a stipulation if it's unfounded? I mean, this woman testified under oath that she had made this comment. So how could you obtain a stipulation that says something different?
I apologize, let me rephrase.
Okay.
A stipulation from the Commonwealth that the Commonwealth has never heard
I see.
of this before. Because, you know, it's one thing for counsel to...
How would that have helped you with the jury?
Because then defense counsel can argue to the jury about her credibility. Because as it came into the jury, they don't really know whether she said it or not. And this
What
is...
if defense counsel said, hey, this plays into our hand because she allegedly made this comment in 2017 to the stepmother, whom she testified she was particularly close to, and it just doesn't make sense that if she said this in 2017, that someone wouldn't have told the police in short order. They waited until 2021. What if defense counsel thought that, and that was his strategic purpose? Again, how do we decide that without a motion for new trial?
My position is that if that had even been his strategy, which I don't think it was because he was completely caught off guard. I don't think this was someone who had been told twice at sidebar in front of the trial judge by the Commonwealth, we have no first complaint witness.
Well, that's a little bit different, though, isn't it? Have no first complaint witness, and the fact that the alleged victim never disclosed to anybody are sort of two different things. In other words, you're saying that trial counsel should have known, caught off guard, which appears that's the case from reading the transcript, right?
Absolutely agree.
So let's we'll say that. What you're saying is that that by understanding that there's no first complaint witness, that also means that this person never told anybody, never confided in a friend, never confided in a teacher, never told anybody. I mean, maybe the Commonwealth just never, as you pointed out, never knew.
I would agree
Okay.
with that second point. It doesn't mean she didn't do it. We don't know. But as
Maybe the question shouldn't have been asked. I mean, this was solicited on cross-examination.
it was solicited on cross-examination after trial counsel was told,
But
actually,
told there's no first complaint, not told that she never said anything to anybody.
well, told that she doesn't have a first complaint witness to offer, which would indicate that there is no first complaint witness.
Well, let's look at the transcript. Transcript 2, page 12. The prosecutor informed the court that the Commonwealth was not offering a first complaint witness and that the allegations came to light when the victim reported the sexual abuse to police in January of 2021. To Justice Vuono's point, that is different than saying she didn't disclose to anyone. And to Justice Neyman's point, there was a lot made of the relationship between the victim and the stepmother, suggesting that they were extremely close, and so that if she had told the stepmother, then to wait till January of 2021 to tell the police seems incredulous because the stepmother sat on this for all those years. Counsel did a pretty good job of arguing that in closing. And I get back to sort of our Zinsser problem, which is, I know you say it's obvious on the record. I can think of reasons why strategically he did or didn't do the things that he did. And without an evidentiary hearing and an affidavit from counsel, I don't know how on this record we decided. I could foresee a different record, post-motion for new trial, that might get you your result, but I don't know how we do it on this record.
I understand your point. I respectfully disagree. I think it's obvious that he was caught off guard and he did not follow up even with the victim herself on the stand. There was no
Could he
further...
have asked for a mistrial?
Yes, absolutely. I listed or suggested a number of possible remedies in my brief, and that is absolutely one of them, yes.
And could he also have, as a strategic choice, said, this makes no sense. My entire defense is that she's made this up, she's not credible, the brother's not credible. I'm just going to argue this because this came out of whole cloth. I'm the one on the ground. I mean, I'm reading a cold record, so I can't see what's happening, right? He's getting the sense that how the jury is reacting to this information, I'm going to let this ride, and I'm going to argue about it.
And we're not hearing from the stepmother.
And we're not hearing from the stepmother. How do we decide that?
I think it's such an important piece of evidence in these particular cases where really,
I'm not suggesting it's not important.
I'm saying I don't think any reasonable attorney in that position can just decide in that moment. I mean, it's clear this was not what he was expecting, that he's just going to roll with the punches.
But
And
what's your closest case of something of this magnitude coming out on cross and an ineffective claim without a motion for new trial?
I don't know if I have one where it comes out on cross, which again is a reason why I think that it's clear that this was not what counsel was expecting, nor do I think he should have been expecting anything else, given the conversations that took place with the prosecutor and the judge regarding whether or not a first complaint witness was going to be offered.
If I may?
Yes.
Because I know that your time
Yes,
is
please,
short.
please.
I would like to talk a little bit about what might be viewed by some of us as
Absolutely.
as your most critical
Sure.
issue, which is that, and in fact, defense counsel was not caught off guard with respect to all of the character evidence and with respect to the prior bad act evidence. It was not objected to. There was no request for simultaneous limiting instruction.
There was not.
There was only one instruction given in the final instructions to the jury, which was accurate, but just one during the course of all the usual instructions that one has. As I recall, nothing preliminary either in the pre-charge, if I'm not mistaken, just not to be swayed by emotion and things of that nature. What do you, would you like to address those points?
Yes.
The biggest
So
issue is
I
the
think
standard of review. I'll preempt you on that. I mean, in other words, our standard of review is such that it's, of course, favorable, not favorable to your client.
Right, because the objections were not preserved. Right, I understand that. So the court is then asked to review for substantial miscarriage of justice. I think overall, this was a number of things that were problematic. One is that many of the bad acts that were offered, although the Commonwealth argued that they were intended to show sort of, to give a background of what was going on in the household, really all they did was contribute to exactly what they're not supposed to do, which was to show a propensity of the defendant to act as a bad mother.
Well, they didn't show propensity necessarily to a sexual assault.
Correct.
But it did certainly go to your client's character.
It did. It did. However, that's where the problem lies.
That's a problem, right.
That's where the problem lies, right. So, I mean, I could talk about any one of them. I think that there might have been one or two that at least had some iota of a connection to something sexual. There was one where she allegedly commented about, her daughter's genitalia, but by and large, a lot of these, some of them even, so for example, the sleeping bag incident, some of these had to do with her behavior towards someone that wasn't even the complaining witness, right. Some of them were quite far in time, temporally. So I'm thinking of the sleeping bag incident. That was quite far in time. Had absolutely nothing to do with sex or with a sexual assault. They were just designed to paint her as an unfit, bad mom and a bad person.
Well, yes, but let me ask you the next question, which is, in Commonwealth versus Morris, we said that the acts complained of consist entirely of acts showing that the defendant's poor treatment of the victim and the challenged testimony, if credible, established the defendant's pattern of disrespect and hostility toward the victim that continued throughout the time of the commission of the rape. So ordinarily, I'm with you, but we have this Morris case, and I don't know if you can distinguish it for me, that show, because understandably the defense here was credibility, that evidence was necessary to put the entirety of the relationship in context as to why, from the Commonwealth's perspective, she was credible.
I think that I would argue that these acts showed a household that was in turmoil.
Absolutely.
I don't think that these acts, or I would say these acts did not have anything to do with the complaining witness's credibility in regards to this particular allegation. This particular allegation, or these allegations, were very different than any of the other acts that were elicited from her or from her brother.
And Bradshaw tells us that those can come in a rape case to explain why the acts are otherwise, if they didn't come in, the acts would otherwise be inexplicable. If you had this perfect household relationship and then you have these two rapes, it makes no sense. And the Commonwealth's entitled to put in at least some amount of the history and the relationship.
Right, so that would be my next argument, is that some, perhaps.
Piling on.
My position here is that these were really not vetted very well, either by defense counsel or by the court. And sort of going back through the record again and again and trying to even discern where particular decisions were made or certain rulings were made was cloudy and is difficult, so.
I'm going to pause you because your time has expired, but Justice Neyman has another question.
Am I correct that 2 witnesses testified to the bad acts?
Yes.
Do you know how much of their testimony consisted of bad acts testimony versus testimony vis-a-vis the incident itself?
So I can tell you that.
2/3, 1/3 ballpark?
Oh, I would say much more than
More than
that.
that?
Much more than that. The brother, almost the entire purpose, I would say, I don't want to say entire because that sounds dramatic, but almost the entire purpose of his testimony was to list bad acts. Perhaps slightly less so for the complaining witness, but also, I would say, her testimony regarding the actual complained of incidents it was minimal compared to the others.
Let me just check with the panel. I don't see any other further questions. We will take the rest of your arguments on your brief. Commonwealth, we went 1:05 over. If you need additional time, I will give you that. Attorney Jansen?
Excuse me. Thank you. May it please the court, Catherine Jansen on behalf of the Commonwealth. I'm going to jump right into what I think is the issue the court wants to talk about, which is the prior bad acts, and I would think it's the Dwyer issue of it all. In terms of, just to answer Justice Neyman's question of the brother's testimony, it was on direct examination, it was 20 pages, and 5 of those pages included testimony about the prior bad acts. I would suggest it wasn't overly detailed, and that his
What else
testimony—
did he testify about? What else was he, for what other reason was he called, except to show the tumultuous, is the word that was used, nature of the
Well, I would
household?
suggest that it wasn't just the prior bad acts. He also testified just about, besides the specific incidents of bad acts, but also about the parental dynamic, the parental-child dynamic in that house. He also testified about the fact that he didn't witness any sexual abuse, which I think was important.
That was a couple lines. Just about everything he testified to had to do with the nature of the relationship between he, his twin, and his mother at
Correct,
that home,
but I would also
right?
say, when we're talking about what are the bad acts, the majority of his testimony wasn't bad acts, but I do think there's a difference between the nature, the dynamic of what it's like growing up in that house opposed to
Okay,
incidents.
I didn't mean to interrupt you, but, so there are specific bad acts, for example, potentially the sleeping bag accident.
Correct.
Then there is other evidence, the screaming, the yelling, the utilities being turned off. Those are not bad acts per se, but they certainly go to character, do they not?
Well, I would suggest, in terms of the utilities, and I know, I'm not to parse, but I know it was framed in the motion limine as a bad act or character, but I don't think the way that it came out was necessarily a bad act. I don't think
What
it
was
came
that
back
relevant?
as an intentional.
As we're on that, how's it relevant?
Well, I think it's relevant just to show that the household and that this victim's childhood was not stable, like everything. It was just another example of the childhood not being stable, and to the extent it's not highly relevant, I think for that reason it's not highly prejudicial, and in fact, I think it could have helped the defendant in terms of there was testimony, even from the victim and her brother, that she was working and that she was trying to make ends meet. So
I don't see the relevance. So they're, either she's poor and she can't afford the utilities for a month, or she's irresponsible and the utilities went out, so therefore she's more likely to rape a child? That makes no sense to me.
no, I think that I think the relevancy is that it just goes to the instability of the victim's childhood, which again goes to possibly reporting or feeling in a safe environment to
The connection you're
report.
making is if someone grows up in an unstable household, they're more inclined to not report a sexual assault.
I think that could be a factor, and I'm not saying that every time a child grows up in an unstable household, but I do think that in the context of this this is just one of the myriad of things about how this victim grew up and what was going on and why she didn't disclose until well after the fact, and I think that could be a factor in it. Not to suggest that every parent that's struggling, there's that connection, but I do think that would make it relevant. To the extent it's not overly relevant for that purpose, I think for that same reason, it's not overly prejudicial, and in fact, it could be used to help the defendant be a sympathetic figure to the jury. I think a jury of adults would necessarily understand those struggles.
But the only evidence that came in with respect to these struggles, as you referred to, as I recall, essentially came from the defendant herself when she testified.
The brother and I believe the victim testified that the reason that
The
she
victim
was
testified that she worked all the time, but instead of saying, you know, she had it tough and she had worked 2 jobs, it was like she was never home.
Well,
We
I
didn't
think-
have dinner. We didn't know where she was.
Well, they didn't say we didn't have dinner. She just said she was working late
implying
at
that she
night.
wasn't there. Okay, that's true. I will withdraw that.
Yeah, and I think it's clear. I mean, they're kids. They're not necessarily, and I think the juries are sophisticated and have common sense and life experiences. I think they are going to understand that this is their kids. Their view and perception of things might be a little bit different. But they never said we didn't have dinner. They just said sometimes we didn't have the utilities. She was working. She worked at night, and that's like why we were home. It wasn't meant that it wasn't the way I read the testimony and how it came in. It was not an intentional act. It was more.
I'm with you on the whole idea that the Commonwealth's entitled to put in some explanation of this family and this dynamic and these relationships. So where is the line? Here,
Right.
there are 11. And so the question that your sister raises about piling on is a question I have. But before you answer that, 2 specific ones I want to understand. Understanding that I agree with you that the law does allow some of this evidence
Yes.
to come in. I don't get the sleeping bag incident and how that relates, and the evidence that the defendant told the victim that her biological father did not want a daughter or care about her or her brother. How do those 2
Sure.
get you?
So first about the first incident about that the biological father said he didn't want a daughter and didn't love the kids. I think that goes directly to the nature of the relationship in terms of how the defendant controls the victim and manipulates her and isolates her, which is highly relevant in terms of the nature of these rapes. They were about control, punishment. They were not for sexual gratification. And it also goes to the delayed disclosure and the isolation, saying your dad doesn't want you or didn't want you, only me, and keeping her in that relationship. So that's why I think it's relevant. In terms of the sleeping bag incident, I would suggest, yes, well, it was the brother and not the victim. It was in understanding temporally, it is a little bit earlier than the charged conduct. That being said, though, this was a seminal moment in her childhood growing up that was part of her fear, and again, goes to the delayed disclosure. I think it is absolutely highly relevant to that issue of the rapes and when she did or didn't disclose, because this is, again, a specific incident where it wasn't just things being thrown around in a loud, tumultuous household. There was some physical aspect to it, and that was scary for her, and that goes to not disclosing until after she leaves the household. So as to those 2 specific incidents, that's why I think they're relevant, and as far as some versus
11.
all these incidents, there is no litmus test as to how much is too much and what's appropriate, and I would suggest in this case it involved an extremely unusual relationship between a mother raping her daughter, which is something I think the jury would have very difficult believing something like this could happen because it goes against the natural order, and that this cannot be summarized by 1 or 2 incidents. It's kind of like a death by 1,000 cuts in terms of we need to see the full picture. It would give a false impression of this relationship.
But there's no litmus test, but the judge himself said that he didn't want this evidence to quote-unquote swamp the trial.
And I think that was in relation to the brother testifying about, in great detail about, I believe, when he got kicked out of the car, and maybe the sleeping bag incident.
Let me ask you this. I didn't mean to cut you off. You made a good point that, of course, the jury evaluates the witnesses and could make some reasonable inferences and assumptions about childhood memories and things of that nature. And, of course, also had an expert witness. But in this case, the judge did not give the jury any instructions as to how they were supposed to consider this evidence when the evidence was coming in. They weren't instructed on that point before the evidence came in or while the evidence was coming in. And then, as I already discussed with your sister, that there was that one instruction in the final instructions. What can you say about that?
Well, I would suggest that, well, the case law obviously does favor a contemporaneous instruction. It's not necessary unless it's requested. And here, the judge twice asked defense attorney if he wanted an instruction. Let me know. Do you want it? It was, I believe, in motions. And then,
what could
as
be
it was
the
coming
strategic
in,
reason, in your view, for that, for declining that?
I would say the strategic reason is that he doesn't want to highlight this evidence, and he wants to be able to argue. You'll have the instruction in the final charge where it has where it points out specifically what you're supposed to be using it for. But this way, it's not highlighting it before the jury more so, and to some extent. To some extent that the defense attorney did highlight in his closing, he used it to his advantage that a lot of these prior bad acts and the renditions of them were not accurate. So I think that is mainly to not overly highlight the evidence in front of the jury for not having a contemporaneous instruction, which I think, I don't know if I found a case exactly in a prior bad act case where this happened, but I believe there are multiple cases where the court has found that not asking for a contemporaneous instruction or limiting instruction is a strategic decision when there's no motion for new trial and we're looking for a strategic reason on the record. In terms of, I believe Justice Blake mentioned Commonwealth v. Morris, which I would suggest is the Commonwealth's best case on this issue of how many bad acts there were. In that case, there were 3 charged incidents, 1 rape and 2, I believe, assault by means of a dangerous weapon. In footnote 14, it lists, I believe, 10 acts that occurred contemporaneously, much like these. I believe the only act that wasn't contemporaneous in our case was the sleeping bag incident, and those all go to the hostile nature of the relationship, and I would suggest a lot of our, and it lists out those specific acts, which is, I think, helpful for the court, and I think that's very similar to this case. And the court there said that it did not overwhelm the case. They didn't go into detail about why not, but which might have been helpful.
With reference, quick question back to the first complaint.
Yes.
Did the Commonwealth reference the first complaint in their closing argument?
No.
Did the Commonwealth reference the prior bad acts or the bad acts in their closing?
Very briefly, only to the extent that you heard about the nature of what it was like growing up in that household, which is a proper, in the dynamic nature of relationship.
Not reference any of the specifics in closing, not one of them?
Your Honor, I don't want to misrepresent the record.
Okay.
I'd have to.
We'll take another look at it.
I'd have to go back and look. I don't believe so, because I think I probably would have made note of that, but I don't want to misrepresent the record.
It's fine.
Okay.
One of the thrust of your argument, it seems to me, on the prior bad acts is that because these rapes were motivated by something other than sexual gratification, we should sort of be looking at these differently. So give me another crime that we could be looking at a conviction for that this type of bad act evidence would come in for.
Apart from like a sexual assault?
Yes.
Was it just murder, maybe? I think DeMarco, which I believe is cited within.
DeMarco?
I believe so. I believe that's cited within Commonwealth v. Morris when talking about the nature and household.
Domestic abuse, right? We
Yes.
know we have lots of cases that talk about the nature of the relationship. What if instead of this being a sexual assault between a mother and daughter, it was a physical assault between a mother and a daughter that resulted in some form of injury? Would these 11 acts still come in?
I think some of them would, and I think part of when you're looking at whether the probative value is outweighed by the unfair prejudice, you're looking at the nature of the acts and if they're so similar to the charged conduct that it ends up being used as propensity for that. And so I think that's in favor of this case, that these are not like the charged incident, so you're not risk at the propensity of that, commit all these sexual assaults, then she must have committed this sexual assault. So that's why it's hard to know. This has to really be a case-by-case analysis in terms of the number and the types of acts. In a domestic violence case that's physical, I mean, some of these which are not physical, I think a lot of them probably would, because again, it goes to the hostile nature of the relationship. But it's hard for me to give a clear answer on that. That's really succinct.
And the lack of a motion for new trial here to help us on the IAC claims, what do you want to say about that?
I would suggest that there are strategic reasons from which the court can find that the defense attorney did what he did in terms of the unanticipated response from the victim on cross-examination that she had reported.
I don't think it's up to us to determine whether there could be.
There could be, but in terms of how it goes to prejudice and did it prejudice, well, I think on this record, you can't really find an effectiveness because we don't know whether these were tactical or not. I would suggest, and I think the case law is consistent with that, you could find a tactical reason by looking at the record, and here the tactical reason for in that case would be this plays directly into my defense, and then he used it, I think, really well, that it was, quote, the most damning of all was that this was not reported until 2021, when she had this maternal relationship and great relationship with her stepmother, and this information was out there for about 3 years before. It doesn't make sense. In terms of the not acting for asking for a contemporaneous limiting instruction, I again would suggest this to avoid highlighting the import of any of this evidence before the jury. And as far as, I believe there was one more claim, but it's escaping me now what the other claim of ineffectiveness was.
Well, what strategic reason would there be for
not objecting
continuing
to the cumulative nature.
Not continuing to object to the 11 bad acts that were admitted in evidence, or I assume you're agreeing that it was properly preserved?
That it was preserved?
I'm asking you.
I don't think that.
If it's not preserved, then
why is that not ineffective to not object to the cumulative nature?
What possible strategic reason could there be for allowing in all 11 of those prior bad acts, or bad acts, if you will?
I think part of when you're looking at whether somebody's ineffective, and I'm not sure if it would necessarily, this answers this, what could the possible strategic reason be, but to be successful in a claim of ineffectiveness, you can't have a futile objection, and I think it's admission of prior bad acts are discretionary on the terms of the judge. I think it's clear from this record that all the parties believe that these prior bad acts, or again, kind of necessary death by 1,000 cuts, were admissible to show the context and nature of the relationship. So on this record, it suggests that an objection on all of them would have been futile, and so.
Well, he objected to 3 out of the 11, right?
He objected to, yes, the sleeping bag incident and the getting kicked out of the car incident in the motions in limine, and then
Your father doesn't.
Your father doesn't love you. The first time he objected to that was at trial.
I see your time's expired. Let me check with the panel. I see no further questions, so we'll have to take the rest on the brief. I want to say, counsel, you both did an excellent job. This is a very difficult case. It is under advisement. What I am going to ask is if the defendant and the defendant's supporters would leave the courtroom first. Ms. Jansen, I'll ask you to wait in the courtroom for 5 or 10 minutes to let people get out of the building, and then have you leave, if that's okay with everybody. Thank you all.
Thank you.
Thank you. Mr. Albert, just have Ms. Jansen stay for about 10 minutes. Abundance of caution. I don't want them to say something during the call. That's right. All right, our next case can get set up. It is Commonwealth versus Darwin Contreras, docket number 24P1397. Ms. Jansen, I don't expect a problem. I just want to give you space. Are we ready? Good morning, counsel. How are you?
Fine, thank you. Please the court, Adriana Contertesi for the defendant, appellant Darwin Contreras. And Mr. Contreras contends that he was materially prejudiced by the precipient police witness testimony of not one, but 2 expert police witnesses on being able to detect drunkenness or being under the influence of sobriety.
Can I ask you a question?
Yes.
Ever since the SJC decided Canty, I have not found a case where the SJC or the appeals court has reversed in a published or an unpublished decision on a Canty violation. Can you point me to one?
Well, me neither, but I don't understand why all the case law that I cited on page 22, every time I come up here with this issue, I always lose. But this is a really good example of how prejudicial it can be, because there were objections to both of the police officers giving that testimony. The Commonwealth, despite the judge's curative instruction, the Commonwealth tells this jury of 6, now you have 2 police officers. They're trained in this. They have expertise in this. And you don't have to be drunk. You just have to be under the influence. How could this court not conclude that that did not substantially sway
Was
that
there an
jury of 6?
objection to the Commonwealth's closing argument?
I don't think so.
Part of the reason is, of course, is that, as the Chief Justice is pointing out, that we are required to follow the law that the Supreme Judicial Court gives us. And how can, there's some minor differences in this case with respect to this case and Canty, but not a lot.
Well, first of all, I think that the court does have to follow the analysis for prejudicial error, and that is there. And then also, too, I think that the court should look at the distinction between 701 and 702. And I note that in the Commonwealth's brief, especially on page 13 and 14, these are never referred to as expert witnesses, and they're never referred to as opinions. They're always referred to as lay opinions and observations by the expert. So,
But their testimony isn't anything along the lines of, can you testify to a reasonable degree of some type of expert certainty that this person was under the influence? That would be a big problem.
well, no, but we're not talking to a bunch of people with microscopes and stethoscopes. We're talking to a jury of 6 regular
The
people.
officer said he was drunk. That was what the comment was.
Yes.
Okay, so that's been
Two
that's
times.
been described oftentimes in our case law as a lay opinion.
Yeah. Well, but that's.
I mean,
and
I
understand.
admire your tenacity. I think you have a good argument. I don't
Thank
want
you.
I don't want to imply otherwise, but.
No, I appreciate
But
that.
saying drunk has been, that exact word, that exact dialogue has been determined to be permissible by our courts.
Yes, I understand, and the distinction between 701 and 702 just does not make any sense to me, and I think that one of the reasons why the Commonwealth came so hard with this at trial was that the defendant really didn't appear drunk. There was an issue of one of the officers who said he was slurring his speech didn't understand Spanish, and everybody, so that's much different. This guy had worked 9 hours. He had his seatbelt on. He was driving normally. And even the booking
And how much
video.
alcohol did he admit he had had?
Well, he had had the 6 or 7 beers, while he was at work. I agree, and it was 8
What
o'clock
about
at
the
night.
odor of alcohol? on
Pardon
his
me?
breath? What about detecting the odor of alcohol?
The odor of alcohol. Well, the odor of alcohol, there were empties in the truck. There were empties in the truck bed, and he had been with
None of
2 other
that's-
people.
None of that helps him.
Well,
Yeah,
But
I
I
mean-
do think that distinction between 701 and 702 doesn't make any sense. I don't understand why we have case law like Ortiz when it
You seem to be
just-
arguing, and maybe I'm wrong, but it's almost as if you're arguing that the Commonwealth is doing a bait and switch. It's setting these guys up as experts, but then sneaking in that purported expert testimony under the guise of lay testimony. Is that the essence of your argument?
Yes, I did say that. I think I said something like the Commonwealth is having its cake and eating it too. So, yes, thank you. So, based on that, I hope that the court will find that this was materially prejudicial.
What
and
kind
it
of
did-
foundation can the Commonwealth lay with police witnesses in terms of their training and experience in detecting that someone might be under the influence? Are you suggesting none? They can't get into it at all?
Well, I think that
I've
there
made
are...
5,000 stops on the road in my career. I have training and experience at the academy in detecting symptoms of being under the influence, and of those 5,000 stops, in 300, I had them perform field sobriety tests, and I made arrests in 80, and here's why. Would that be okay?
That's an expert witness. That's not a precipient witness. There's a difference.
Because it has to be limited to the circumstances here. So it seems that that's what the police officers did. I have training and experience in detecting, or I have training from the academy, a 2-week program in detecting people who are under the influence and looking for certain symptoms. Okay? Why is that not okay?
Well, I did these field sobriety tests. I concluded he failed. I did the 3-step turn. I concluded he failed. Don't give the opinion. Let the fact finder, leave that to the fact finder.
So that you have to make that wonderful argument downstairs,
Yes.
right? We're stuck with we have the law as
I'm
we
up
have
here.
it. And the jury knows what the charge is, right? That's the other thing that's so hard in these cases. They are sworn in as a jury to hear a case of operating under the influence of liquor. It is not going to come as a surprise to them that the arresting officer says, I thought he was under the influence of liquor.
I just have one final question, which
Yes.
is, assume that the officers had not testified to their training and experience in detecting symptomology of being under the influence. Could they then have provided an opinion?
Then I wouldn't have had this argument that they were expert witnesses in detecting sobriety. And that's why it's unfair. It's not a
And I
fair
suppose
trial.
also what you would bring to our attention is how one of the officers, I'm going to use the word indicated because he kept referring to indicators, which he learned about not from lay experiences, but from the academy.
Correct. Thank you. Yes.
I
So
can ask you about the Brown case, which is a case out of this court, where we said, because a lay juror understands the effects of intoxication, an officer's observation of a defendant's behavior during a sobriety test remain within the realm of common experience. So if that's the state of the law, the next step of the officer saying, based on my observation, including what happened in the field sobriety test, I formed this opinion. I see that as a natural extension of Brown and Sands and Rarick and all of those cases.
as a lay person but not as a precipient police witness who's an expert in detecting
Well,
the signs.
of course they're a precipient witness. They were at the scene. So
Right.
it's not that they're a precipient witness. To Justice Neyman's point, you're suggesting that they did a bait and switch between a lay and an expert.
Yes, and rob the jury of its fact-finding function. I would move on to the reasonable suspicion argument.
You want to address the submission of the 9/11 tapes?
Well, I did what the court has asked me to, and I went around and around and around this issue, and I have to say that, I want to just take my notes for that.
You don't dispute that they were played at trial.
I
I mean, at the motion hearing, excuse me.
It seems like something was played, but I don't know what it was.
Well, they say it. I mean, the case was kind of reopened. There was an argument that everyone left the courtroom. They came back to argue the case. The judge says, you gave me case law on Aguilar-Spinelli type cases.
Right.
Why? You're not raising that. And then the defense counsel actually says, we can hear the tapes. And the tapes get played. The transcript is pretty clear the tapes are played at that point.
Yes, but if you go to Waltham Court, the docket entry sheets say exhibits at the motion hearing, 0. There's no CD in the court file. This is not
The transcript is clear. The defense counsel says, we can hear the tapes. First, they were going to play the CAD report, and then the judge says, okay, we can reopen. She basically says, I can't remember the name of the judge. Thank you. Says, well, we can reopen to hear it.
Yes, she reopened the yes, but where's the CD? What CD? What tapes?
Well, is there really any question as to how, there's only one set of 9/11 tapes, right?
Well, I was asked to consider this, and I
Okay.
was asked to consider this, and I will say that if it helps me today, is not the reason why I am coming to this conclusion. I'm coming to the conclusion I'm coming to because the court has asked me to research the thing and be prepared, research the issue and be prepared. So I am concluding that the court should not allow the Commonwealth's motion because although the court Rule 8 authorizes the court to go ahead and make that addition to the docket or the change to the docket, I think that the record establishing that the CD that is proposed to be added to the trial record there has not been a case made yet that it carries enough reliability for the court to exercise its powers under Rule 8 and admit that. And I'm not doing that to punish the Commonwealth. I understand what the situation is. I'm doing that to not make bad law.
So your point is there should be a hearing, and the judge should make a ruling that, yes, these tapes, Commonwealth, that you're playing for me right now, were the tapes that I heard, and therefore I am going to say that these are exhibits and say, I should have maybe marked them, I did not. These are the exact tapes I relied on and referred to in my findings. And then that will be following the law, explicitly. Is that your point?
In the alien warnings cases and probation conditions cases, there's lots of interesting case law about docket entries and changing docket entries. So a docket entry is presumed to be a correct reflection of the record.
Your point is follow the procedure.
Well, I'm not saying that the court does not have, that Rule 8 does not give the court authority to do that, but I have some reasons why the court should not exercise that here. First of all, even if I had assented to the Commonwealth's motion, it would not have made any difference in the reliability because I have never heard the CD. I don't know what happened. Even if I asked the trial lawyer, what would he say to me? Well, I guess, I don't know.
Well, the record reflects, this is the motion hearing, page 11, that I have the turret tapes pulled up. They're about 6.5 minutes long. So if we get turret tapes that are about 6.5 minutes long, are you really disputing that those are the turret tapes that were played for the judge at the motion hearing?
I think it would make bad law.
All right, perfect.
I'm sorry. I think
The
it would.
911 tapes were played
And
as
defense
well.
counsel wanted them played. We should hear the 911 calls. I'm quoting from defense counsel on page 11 to 12.
I agree. I'm talking about
Okay.
this court ensuring that if it's going to exercise its authority under Rule 8, that there needs to be reliability. So if I'm going to just,
Let me just ask you procedurally, right? The whole case has been briefed, and argued. So we stay the proceedings, we send it back for a reconstruction of the record, these calls get docketed, and then it comes back up and we decide the case. Is that?
everybody gets a chance to write a new brief, because if not, there's a due process problem, because I hadn't heard those tapes
You've
until...
never heard the tapes?
Not until 88 Charles sent them, and it seems like whoever wrote this brief, the Commonwealth's brief, had listened to the tape. So that is another reason why I don't think, I think
So a
that...
new briefing schedule as well, to add on to what the chief is pointing out.
So I think it would raise a due process problem.
But if you were able to have
Pardon me?
if you were able to resubmit a brief, that would eliminate the due process problem, correct?
Well, it would eliminate the due process problem, but it still wouldn't eliminate the reliability problem. So
What do you mean by that?
I do have two things to say about the affidavit that was submitted by the court. And the first thing is,
Submitted by the court or submitted by
I
Attorney
mean,
Charles?
I'm sorry, I stand corrected, submitted by the Commonwealth. So the first thing is that I think in paragraph 6, hold on, I want to just find my copy of it. Okay, so, no, I'm sorry. In paragraph 8, I want to object to paragraph 8. That is a complete mischaracterization of the interaction. When I received an email from 88 Charles the other day, I responded politely and promptly, and I did give a rationale. And I hope that 88 Charles would not intend the court to have a bad opinion of any interaction because of what's written there in Affidavit 8. So
I didn't read it as a negative.
We wouldn't
Paragraph
take it that way.
Oh, thank you. Okay, so the second thing is that paragraph 6, if paragraph 6 is what this court is going to rely on to find that that CD is reliably what it is purported to be, I just don't think that that's enough. It's not even the trial ADA saying, I've listened to it and this is exactly what it is.
Final question from me, because your
Judge.
time's up. Under what authority is it not enough? What's your legal basis?
Look
for
at
me?
all the cases, look at all the alien warnings cases, look at McDonald's, everything relies on an affidavit coming from down below. Does the court want to start making decisions for the lower, if the appeals court wants to start substituting its judgment about what was in a record and what was not without some kind of evidence that reliably rebuts the presumption that the docket entry is not correct, I think it would set a bad precedent for everybody, not for everybody. I think that the court should decline to do that, but as I said, not kill the case. There are other ways for this to happen.
I think we're going to have to leave it there. We're certainly going to hear from Attorney Charles, but if we decide to enter an interim order, we'll
Thank you. I don't
certainly
want
do
to
that.
punish anybody, but I don't think it would be the
Thank
proper
you.
thing. Thank you.
Attorney Charles. Can we start where counsel left off?
Yes, good morning, Your Honor. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. The Commonwealth is vexed about the argument it just heard. It is the burden of the appellant to create an adequate record. One of the central issues raised in this appeal is that the motion to suppress was improperly denied. The transcript clearly reflects that the parties listened to the 911 call, that the judge refused the Commonwealth's offer to put the CD into evidence and said, we played it, it's part of the record. I'm good.
Can we
And then-
decide this case without the 911 calls?
I don't think it's the appropriate thing to do. You can certainly accept the motion judge's factual findings, which are based
I
on the
should have
911
said solely on
calls.
the motion to suppress claim, not on the
Sure,
trial claim.
I understood Your Honor's question. The motion judge made findings of fact. The officer made reference to receiving 911 calls that referenced a red truck. But in light of the Aguilar-Spinelli claim on appeal, to assess the reliability of the callers, were they identified? What information did they provide in terms of the specificity of what they were observing and what was occurring? I think you have to hear the 911 call.
Do we
And
need,
so
do we
to hear
need
my
to also
sister's-
hear, I'm sorry to interrupt, do we also need to hear the turret tapes, or no?
I don't believe Your Honors need to hear the turret tapes, because I think if you read the motion judge's oral findings in the record, they are largely reliant on the testimony of the officer and the content of the 911 calls. But
So this is where, if you could follow along with me, in the motion to suppress transcript, starting at page 9, the judge says, as far as the CAD recordings, it's your burden once it's raised, so if you want to introduce them, I'll listen to them, but he doesn't need to introduce them. Some more discussion. Line 20, I think Ms. Lee is the Ms. Lee the prosecutor or the defense attorney below?
I'm sorry?
Ms. Lee is who, the prosecutor or the defense attorney?
The prosecutor.
Okay. So then she says, I would be more than happy to play them and provide them right now. I would like to introduce them if, and then, of course, simultaneous speech, inaudible. This is the whole conversation about reopening the evidence. On the next page at line 8, the judge says, so that's the only thing you would be asking as additional evidence. From all of that, you take that they played the submission that we asked you to file with the court.
Yes. At the bottom of page 11, top of page 12, Mr. Reinhardt, I would think, the defense counsel, I would think, though, if we're concerned about, and it's inaudible there, reliability of the initial call, we should hear the 911 calls, which we have. Court, do you have those? Prosecutor, I do. Defense counsel, they're pretty short.
Video
being played. Okay, thank you. And then the prosecutor offers it on a disc. She said, no, it's fine because it's all on the record. And then the court makes findings that specifically reference the contents of the 911 call. So, again, to hear my sister, I don't want to create ineffective assistance of appellate counsel, but to hear my sister say she never listened to the calls, they're a foundational piece of the claim she's raising on appeal. So didn't contact trial counsel to see if trial counsel had a copy, didn't seek to reconstruct the record. And then, I'm a little embarrassed myself that my initial thought when I was writing the brief was, I'll just move to transmit. I should have probably moved to reconstruct the record myself. So I'm a little embarrassed, candidly, that I didn't do that. But then when the Commonwealth seeks to correct the record itself to just, I wasn't intending to besmirch my sister or put a negative gloss, but I didn't
take it that way, Mr.
receive
Strauss.
a reason. The email I received.
In all fairness, both of you are faced with the fact that you weren't in the courtroom at the time, and the judge says, it's all on the record, so we don't have to do anything more. So
And
you're
I did
both
speak-
faced with something that wasn't done procedurally, perhaps in the best possible way, and you're each taking a different side as to how to address that.
And I did submit an affidavit under oath indicating that I spoke with the trial ADA, who indicated that the file that was provided to me was the copy of the 2 911 calls that were played for the court at the motion to suppress. So again, I wasn't there. All I can do is rely on what the parties say. I think I did request as an alternative remedy that this get sent back down. If we have to go through that whole long, drawn-out procedure, I will do it. I don't think it's necessary, because I think the averment in my affidavit that this was what was played and the reflection in the motion judge's findings, and by the way, I think the motion judge was Justice Quealy, and I may in my affidavit have said Justice Kahlo. It started in the first session and moved, so I apologize for the confusion.
Paulo
There's
was
a
the
mistake
trial.
I think there's a mistake in the transcript.
There are several mistakes in the transcript, including the date of one of the hearings. But, it will be rectified however it needs to be rectified. I certainly don't think that there needs, assuming your honors conclude it needs to go back down, I certainly don't think there needs to be rebriefing. The 911
Why?
calls speak for themselves.
Why? Because let's say we recreate the record and counsel now has, I don't know, a different argument, a more enhanced argument on her motion to suppress claim. Are you saying it's waived?
Well, I would say, I don't see how it could enhance her argument. I mean, I've made an argument in my brief that both callers identify themselves, one by name, address, and phone number, the other one by phone number. They are watching a real-time event and observe the police arrive. One of them is walking on the street that the truck turns onto because they live on that street. So I don't know how you could find on that record, with whatever you might hear in the calls.
That's a point well taken, but, defense attorneys sometimes can look at things with a different view. So would not be a shortened or abbreviated briefing schedule, I'm imagining some of the
That's a point well
Commonwealth,
taken.
that the Commonwealth would not object to.
The Commonwealth will be submitting the same brief. So if we need to come back up and I need to argue before your honors again, I suppose that's what will have to happen. I think your honor should just accept the file. I do think the transcript is clear that it was played and considered by the judge upon the agreement of trial counsel, who thought it was essential to the resolution of the issue that he was raising at the motion to suppress. So I suppose at that point, I'll leave it at that. I think I've kind of articulated my argument on the Aguilar-Spinelli point at this point, contemporaneous calls from callers who are identified, who essentially see the officer pulling up and it's like, oh, you're pulling up now to the truck. And it's the only red, I'm sorry?
The red truck.
The red truck, it's the only red truck in the area. The officer says that he doesn't see a lot of traffic at this time of night, non-resident traffic. The path of travel of the vehicle, if it was a residential vehicle, was odd or suspicious to him, given that it was not a way to extricate yourself from the neighborhood, coming from within the neighborhood. I think on a reasonable suspicion standard, even though he's initially looking to respond to this individual due to a fight and not a prospective OUI, I think the basis for the stop to question him is certainly supported by reasonable suspicion.
Why don't you move to the Canty question?
I mean, the Commonwealth's intention, unless your honors have questions, was to rest on its brief. The SJC has said what it said. I've cited numerous published and unpublished decisions of this court essentially stating that this is acceptable testimony. I've summarized the officer's training and experience, which was essentially them just saying, I was in the academy for a week and we observed some people who were drunk and practiced field sobriety
Does
tests.
it matter that there were 2 officers here instead of 1?
No, I don't think the Commonwealth is limited. There's no case law that suggests that the Commonwealth has to limit its evidence. I suppose the defense attorney at trial could have filed a motion in limine seeking to have that limitation imposed on the Commonwealth. He did not. I don't believe the testimony was particularly detailed. Again, I summarized it in my brief. It's essentially a couple of lines saying what their observations were. As Your Honors noted, the defendant admitted to consuming a substantial amount of alcohol, and there were empty cans of or bottles of beverages observed in his car. So this wasn't a case where we're relying solely on the testimony of the officers. There's corroborating evidence in the form of admissions that this individual consumed alcohol. I think a lay juror understands that 2 to 3 beers will already put you over the limit. So an admission to 5, 6, 7 beers being consumed is a pretty substantial number. So even if you were to find it to be error, which I don't believe this court's allowed to do in light of SJC precedent, I don't think it substantially prejudiced the defendant in this case. So if there are no further questions, I'll rest on my brief.
I see no other questions. Thank you. The case is under advisement. We will let you know either in the short term or as part of our decision what we're going to do on that procedural issue. Thank you both.
Thank you, Your Honors.
We're going to hear one more case before the morning recess, and that is Commonwealth versus FELIX, EDILIO, DELEON. I'm sorry if I've mispronounced that. Docket number 25P610. This case is partially impounded, so counsel, please comply with those rules. Good morning, Mr. DiMaria.
Good morning, Your Honors. May it please the Court, Daniel DiMaria for the appellant, Felix Edilio de Leon. Your Honors, a wellness check is not an arrest. Officers arrived to check on a man they believed may be comatose, who might have been having health issues. They spent 15 minutes speaking with him. They let him call his brother. They testified their goal was to find a solution other than an arrest. They never once said, "You're under arrest."
You don't have to, under the case law.
You're right, Your Honor. They never turned on their cruiser lights. Then they tase him twice and drag him from his car. The Commonwealth says...
There's a few things that happen in between.
I assume Your Honor's referring to the beer where he moved a beer from the holder to the leg, opened the door, poured it out, and tried to close the door.
Well, let me ask you a question about that. Do you agree that once the police see the open container, which he initially moves, they said almost like to hide it to the floor to the right, and then pours it out, that there's probable cause at that point to arrest him for open container violation, since it's a misdemeanor committed in their presence?
The question is what Mr. De Leon would have thought himself.
I want an answer to my question before we reframe it. So, is there probable cause at that point to arrest him for open container?
There would be, Your Honor, yes.
So now tell me how you get around that.
Yes, Your Honor. So under the Grant case, it's would a reasonable person in his position have so understood that that was a crime. And I will also point the court out, I don't believe this in the briefing, but in jury instruction 7.460, it says that the jury may consider whether the defendant was intoxicated in determining whether the Commonwealth proved that the defendant knew he was under arrest. And again, that's jury instruction 7.460. It's at the back of my brief. And so I think that assists me as well. Now,
So where I'm struggling a bit, because you make a very interesting argument, and I've read Sanderson and Porty and all of those cases, it's a reasonable person standard, correct?
yes, Your Honor.
You've set forth a version of events from which it could be believed that your client did not know or was not aware that he was being arrested or likely being arrested. But couldn't a judge have found, based on that totality, that a reasonable person in your client's position could have been aware that he was being arrested?
I don't think so, Your Honor. Simply the way this entire thing unfolded, again, it starts as a wellness check. He gets to call his brother. The officers testified the goal was to find solutions other than an arrest. So I don't think they behaved the way officers ordinarily would have when trying to arrest someone. I would argue that commands to exit and to stop resisting, these are not arrest announcements, and that there was no objective communication of an intent to arrest.
Well, what would a reasonable person believe, or what do you think is reasonable for a reasonable person to believe when officers are saying, stop resisting, get out of the car, stop resisting, and announces the taser?
I think that that it communicates a threat of force, and I think that in his state, the way he was in, he didn't appreciate.
That's not the issue, what his state was, what he did not appreciate, as Justice Neyman is pointing out. It's what a reasonable person would appreciate, right?
Yes, and I would argue that to a reasonable person, force does not equal arrest. Officers grab people, let me say, for example, Your Honor, during protective custody, they grab people for pat frisks, for medical interventions, and so on. So I don't think that grabbing him out and pulling him out and even saying stop resisting.
Your point is that other possibilities are reasonably inferable in addition to or other than the fact that he's being arrested.
You
right?
said it much better than I could have ever said it. That's exactly what I was trying to say,
Well,
Your
I'm sure I
Honor.
understand your point.
That is my point exactly, Your Honor. And I know the Commonwealth in its brief, they cite Porty, but in Porty, the defendant had just assaulted a trooper right before. So even though in that case they did not use the word arrest, if you assault a trooper, you would naturally appreciate that you would be placed under arrest. And I think
So
what we...
factually, do you have a case that's most like this one, published or unpublished?
Can you repeat the second part of your question?
Or published or unpublished, do you have a case that stands for the proposition that there was insufficient evidence of knowledge of arrest that is more similar to your fact pattern?
I think the two most similar ones are Quintos Q, that a stop does not equal arrest, and Grant, that flight during a stop and frisk does not equal arrest. And there has to be some objective indicators, words, accusations, cruiser lights. Every one of those is absent here. I don't know if it would have made a difference if the officers had turned their cruiser lights on, but that would have been another...
Isn't one of the factors that can be considered the number of police officers around? And during this interaction, at some point there's 3 police cruisers there, and there's 4 different officers, I think, or at least 3. Isn't that a factor that can be taken into account?
I haven't seen that in any case, Your Honor, but I would say that even in the examples I had mentioned, protective custody, a pat frisk, a medical issue, there could easily... I think it's rare that you have fewer than 2 officers. I don't think 3 is anything unusual. And I think it might have been different as well if we didn't have this 15-minute, segue. If it started off, differently, he didn't get to call his brother, then it might be an entirely different case. But the way...
But you would agree, there are plenty of, unfortunately, with today's substance misuse disorders, there are plenty of times where police officers are called to scenes, not because they're going to arrest somebody, but because somebody is either having a medical, drug, or alcohol incident, and that can quickly escalate into something that becomes arrestable, sometimes because of the drugs and alcohol in the system. So no one, including the Commonwealth, is suggesting that when the police arrived on scene, they were going there to arrest him. They were, as you pointed out in your opening statement, this was a wellness check. But it escalated to something different because of your client's behaviors.
I think we can probably all agree that the best course in a perfect scenario would be for the officers to say, you're under arrest.
Sure.
Come with us.
Is that a result you really want to advocate for? I mean, you have the police officers here who are doing a wellness check, who at least initially are saying, maybe we'll cut this guy a break. Maybe we will not arrest him. Do you want them in all of these situations, as soon as they see the open container, just to say, hey, if we hesitate or we don't say you're under arrest, we have this case law that's a real problem for us, so screw it, we'll just say you're under arrest?
Oh, absolutely not, Your Honor. But I'm saying, once they decide, hey, we're going to arrest this guy, at that point, hopefully, after giving the citizen, a fair amount of leeway, the best course would be to say, you're under arrest. And I think that's
The clearest course would be to say, I agree with that that's the clearest course, but our case law says that's not necessary.
Our case law again says that you basically need to look at the totality of circumstances. And I just think with no cruiser lights on, with the way it all unfolded, the way the jury instruction allows us to look at intoxication as a factor. And as the court knows, he was not convicted of any OUI-related offense. And so I think all of that is to say that a reasonable person on those facts may not have known they were.
We had something here that we don't often have, right? Is this the case where we had the surveillance video from the liquor store?
Exactly.
So the jury actually got to see this play out in their own eyes, and they can draw conclusions from that tape, right?
Yes, Your Honor, they absolutely can. It did not have any sound, but they did have the video. And I think the video shows a long, drawn-out encounter, and
I don't know that the video helps you, right? Because the jury can make reasonable inferences from what they see. They're not just relying on the police officer's testimony about what occurred. They see it essentially in real time.
yes, Your Honor, but no element may rest in conjecture. The inference that force equals knowledge of arrest is equally consistent with a reflexive self-protection against unexplained aggression by the police. Rather, it's just as likely as resisting arrest. And so for those reasons, I would say the court must either reverse the case or order it dismissed. And if there are no questions, I would rest on my brief.
I don't see any other further questions. Thank you very much, counsel.
Thank you.
Good morning.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. There was sufficient evidence in this case for the defendant's conviction of resisting arrest where a reasonable person in his circumstances would have understood he was under arrest. And I think there's a key factor that no one has said yet, which is, so we have the officers going on a wellness check. We have him refusing to open the door. He then opens the door to pull out the beer and dump it. But the factor we haven't talked about is he starts the car. He turns the car on, and I think as soon as he does that, that's what switches this to an arrest, because he is trying to now go away, and that would be an OUI under the officer's opinion. That'd be probable cause for an OUI. As soon as he does that, the officer then tells him to get out of the car.
Is there probable cause prior to that to arrest for open container?
Yes, I think there's open container, but I think the key thing that turns this is when he turns the car on.
So in other words, you're suggesting that a reasonable person, the defendant's shoes, may have thought that the police were giving him a break or may not have known that open container was a crowd or what have you.
Definitely, Your Honor.
But once he starts the car, that's
And the
a deal
officer says,
changer.
shut it off, get out of the car. A reasonable person in that circumstances would now know they are no longer free to leave. He then says to them, I'm not getting out of here, you're gonna have to fight me. He then physically assaults the officers by fighting them, so I agree this is just like Porte, which I think is the Commonwealth's strongest case. Porte, where they physically fight and he maces them, and this court found that that was enough that a reasonable person in that circumstance would understand that they are now under arrest. He then is tased 3 times, not 2 times. The first tase is the one up close with the electrical one as explained, and then
But there were 2 of those, though.
no, there's 3. The sergeant then, so the first officer, and I'm blanking on his name, I apologize, says he does the first tase, which I guess goes to direct contact, and it says it had no effect on the defendant because they thought the thickness of his sweatshirt. The sergeant then comes and says, like, basically, and you can see it on the video, like, move out of the way, takes his taser out and yells, taser, 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 stop resisting. And the defendant, again, still physically fights the officers. He tases him the first time, in the chest or shoulder, I believe. They testify he's still fighting them. It's starting to have an effect, but he's still fighting the officers. They tase him a third time in the leg, and then they're able to get him out of the car and place him under arrest. I would suggest that's ample evidence that a reasonable person in the defendant's position, I would suggest after the first taser, would know they are no longer free to leave and that they are now being placed under arrest. And I ask this court, under the light most favorable to the Commonwealth, to affirm the defendant's conviction for resisting arrest. If there's no further questions, the Commonwealth rests on its brief.
I see no further questions. Thank you both.
Thank you
Well
both.
argued. The case is under advisement. That is the end of our criminal list this morning. We will be taking a brief morning recess. We will return with the Department of Children and Families case. Brief recess. Thank you. We are returning to our list. Sorry. The first case is Department of Children and Families and Another versus Mother and Another, docket 25P 885. My understanding is that Father and Mother's Counsel are splitting their time equally at 7.5. Child and DCF Counsel are splitting their time equally at 7.5. The case is completely impounded, so please do not use any names. And who are we going to hear from first? Mr. Robin?
Yes.
Please proceed.
Members of the panel, may it please the court, my name is Jeremy Robin. I represent the mother appellant in this appeal of a decree finding her currently unfit and terminating her parental rights. Let me begin by saying something on which I think we can all agree, which is that this is not the typical termination case. In the typical termination case involving substance use history, a parent may sustain some sobriety for a couple of months, a few weeks, engage in some services, sign some releases, show up at trial and say, here I am. I'm ready to take custody of my child. Court will typically say, you haven't sustained sobriety, there have been 2 steps forward, 1 step back, etc. That is not the case here. Here we have the opposite. We have a parent who sustained sobriety for 2 years, a parent who engaged in every service Department of Children and Families asked the parent to
Can
engage
you
in.
help me with the timeline? Relative, the child was born in 2022. What were the 2 years of sobriety that predated the trial?
Shortly after the case was brought in by DCF under the Care and Protection petition.
Before or after prison?
I think it was during prison, during some of prison. Mother came out. She went to my sister's house, a substance use and mental health program. She engaged in parenting groups, NA meetings, individual counseling, and completed an addiction counselor program, was selected as the graduation speaker because of her progress, her engagement. And in fact, the judge himself credited Mother and said that she had been, quote, stellar and commendable. But then he said, well, wait a second, there were guardrails in place. It was too much of a controlled environment, so I can't really give you the entire credit for this. That somehow there's a disqualification. Even though you did a great job, there were guardrails. And
That part is at least true. I mean, there were some restrictions.
Correct.
And
That is true. However, in all of these cases, there need to be guardrails. In any care and protection case that comes in, there have to be eyes watching a parent. It's not a self-reporting system. And particularly where you have substance use history, there are guardrails. And frankly, for a person with the history that Mother has here, there will be guardrails forever. And while DCF has custody, these guardrails are necessary, as I say, for them to see what's going on, for the visitation. They're always supervised. It's not unsupervised, and the parent doesn't say, well, I did a great job, I fed the child, et cetera, et cetera. There are guardrails. There need to be guardrails. So to somehow discredit Mother or disqualify her because of these guardrails is unfair to the process, and it misapprehends what the law is here. So that's what our position here is that the court abused its discretion, and how else can the DCF assess a parent's progress except if there are guardrails in place? So by saying that and commending Mother and saying you've done every single thing expected of you, you've been commendable, you've been stellar, you were the graduation speaker, etc., still going to find you currently unfit and terminate your parental rights. So the court's decree of unfitness and the termination of parental rights was consumed with this fear of Mother's substance use history and substance use past, even though for 2 years she had done the very thing that we ask parents to do in these cases, which is case comes in, whatever the past was, whatever issues caused the case to come in, we've all seen them, mental health, substance use, domestic violence, address these issues, understand them, process them, improve on them so that you can be a fit parent. And that's exactly what Mother did, yet it still wasn't good enough for this trial court because there were the necessary guardrails. The very definition of care and protection cases, there are guardrails. It's a controlled environment. How can you not have a controlled environment when DCF has custody?
What do we do about Mom's expert that doesn't help in all respects
Correct.
and sort of foresees what might happen?
Well, yes and no. I can't entirely agree with that.
Okay, fair.
Because-
That's fair.
Because from a practical standpoint, in these cases where DCF has custody and a parent is seeing a child, excuse my pun here, but it is in a controlled environment during supervised visits, and are we asking a child to just jump for joy and run over to see a parent and, you know, say and do the right things? It takes a little while to adjust to that. And so I think, yes, the assessment wasn't glowing, it wasn't perfect. However, it doesn't really factor in the practicality of the situation. And the real calculus here is, what has the parent done? Current parental fitness or unfitness has to mean something. And it means, what has the parent done to show that they're currently adequate as a parent?
So this is always a hard question to answer, and I do understand that. Is it your position at the time of trial, look, I know you weren't trial counsel, but looking back, that mother was fit, or that the department didn't prove that her fitness was indefinite?
Both.
So she was ready to resume custody time of trial.
True, but again, the practical reality is...
It'd have to be a transition.
There'd have to be a transition, correct. So the latter question, Your Honor, implicates termination of parental rights. The former would be whether she was currently
Current
fit. And I think
fitness.
she had proven her current fitness, that she had understood, for instance, she engaged with the YMCA with the domestic violence. She understood the triggers. She understood what caused anger, et cetera, and how
Do
to...
you have any criminal cases open and pending at the time of the trial?
I'm not 100% certain. There may have been probation. I'd have to check the record on that. But she admittedly had a criminal record. She admittedly had a substance use record, and so on down the line. But that's the remarkable part to this case, is that in spite of all this, in spite of all these odds, isn't this what we want to see a parent do? To make a complete 180, which is what she did, even by the admission of the judge, but he still didn't find in her favor, even though he admitted that, as I read the findings.
Were mother's parental rights terminated as to her 4 prior children? Or just 3 or 4? I think it's all 4.
It may have been. I know she lost custody of all 4.
One was voluntary.
One was voluntary, and
Okay.
I guess my question is, well, it's about the relevance of that. If the mother here was on, for lack of a better term, a clean slate, and this was her first child, let's say, and didn't have that history, that makes this a better case for you, I think.
Yeah.
To what extent could the judge have taken into consideration that prior history?
I would agree.
Is that fair game? in
Yes,
other
it is.
words?
It's relevant. It's certainly relevant, and I think case law bears that out. But it's not determinative.
Right.
And again, I think it, in some ways, is helpful because it shows how big the obstacle was that she overcame. I mean, it's, again, it wasn't a week, it wasn't 2 weeks, it wasn't a month. 2 years. That's a significant amount of time for a person with the issues that she was dealing with. And she, I think she said words to the effect of, I'm ready to be sober.
It
simple
certainly
as
makes
that
this a
sounds.
much tougher case. I agree with you.
Yes. Thank you very
I know
much.
your
for your
time's
note.
expired. Let me just check with the panel.
Thank
Okay,
you.
Thank you very
Thank
much.
you very much. Attorney Young? Good morning.
Good morning. Robert Young for the appellant father. May it please the court.
Can I ask you the same question
Yes.
I asked Mother's Counsel, understanding that it's a difficult question, which is it your client's position that at the time of trial, he was fit and ready to assume parental responsibility, and/or that the judge erred by finding that his fitness, the question of his fitness was not or would be indefinite?
So I think it's clear, there's clearly a lack of evidentiary support for the indefinite unfitness finding for both of these parents. Clearly, they'd both done some serious recovery work over 2 years. They were functioning as a team. They were going to function as parents together. They had, in my reviewing the record, it did stand out to me that the judge, the findings are essentially silent as to their circumstances on the
close of trial. In September of 2024, as the trial wound down, the parents were given leave to appear remotely because they were moving into a new apartment, a two-bedroom apartment, and needed to meet a mover or utility turn-on or something like that. They couldn't come into court that day. Then the judge gave permission for them to appear remotely. That's nowhere in the findings. But what that signified was that they had completed their their treatment programs. They had obtained suitable housing for themselves and their child. And in fact, the judge, not that it amounts to much, but I think it's notable that the judge does make an erroneous finding, I think it's finding 149, a subsidiary finding, which I don't make a big deal about, but as if the father's still in the Opportunity House program, and he had completed that. So does the timeline run pretty tight up against the conclusion of trial to say current fitness? Maybe.
Because he seems to make a big deal, in my view, my words, of the 2 years of sobriety contrasted against decades of substance misuse and criminal activity.
Well, the truism of these cases is that every parent has a history. That's how we end up here, right? It's what do they do with that history? Does the history continue, or to quote from the case law language, does the vitality of that history recede? By virtue of their conduct, what do they do to cut off that history? So 20 years, 10 years of substance misuse and interrelated criminal behavior, that's a given. There it is. That's why this case starts. But when we end 2.5 years later, what does it look like? We see both parents having not relapsed for 2 years, completed their criminal probation. As far as I know, I think mother had completed hers. I don't have a record site for that, but other than the Kari. And the father was set to conclude his in November of 2024, so 2 months after the close of trial. He was doing clean screens. He was completing a myriad number of programs, all aimed at attaining fitness to parent his child. And remember, the standard here is minimally acceptable competence, being able to provide minimal acceptable care. And I think we often talk in these cases, particularly to reverse it, this idea when there's an abusive parent couple, right, the failure to leave the abuser, that wasn't here. And with this idea that we look at the couple as an entity, how are they going to function together? And in the closing months of trial, there was evidence that when they met with the child together, they worked as a team, they supported each other. This, to your question earlier, Justice Neyman, this is the father's first child. And what's different is that that was his motivation. He testified to that. He was clearly motivated to change his history.
So I know you cited IDENA, which is an unpublished case, and yes. I think in that case there had been 3 years sobriety, and we reversed in that case.
Yes.
But and I know this is as to mother, but I think the question for me keeps coming up as to father. Sobriety is a difficult thing to maintain, and I give both the parents a lot of credit here for what they've been able to do. So on a good day, it's hard to raise a child. They have not raised this child. This child has been in care since she was born, essentially. So now you have two parents, both with polysubstance issues, both with criminal records, who have worked really hard with these, as the judge used, high walls around them. And then you plop a 4-year-old into the mix. I have a hard time with a 4-year-old.
I won't argue there. All of that is true. The question is, in IDENA, and the reason I'm glad you brought this up, Justice Blake, is the facts in the case were worse than what we have here. And
well, there was DV in that case, right?
And there were multiple relapses, multiple dirty screens. So the 3-year sobriety mark was punctuated by other positive screens, and as also with methadone or Suboxone maintenance, missing multiple doses. So it was pretty shaky for that mother. My reading in that case is it was reversed because of the nexus, the failure of the judge to draw an appropriate and adequate nexus from the substance abuse to the unfitness termination finding. And what we have here, this is what troubles me about this case most of all, is that we have a judge who says the nexus is the structured treatment. Right. The fact that these parents have this lifelong addiction issue, just like any other disease, and because they are functioning with structure and supportive services, that is what links to their history. And because that history is so severe, they haven't done enough. But this is, what more can we ask of a parent in this circumstance, but what exactly both of these parents did? And the child, we don't compare foster placement with their ability, who can do a better job. They were demonstrating in the closing months of the trial that they were ready to parent, and that they had a place for their child. They supported the kinship placement. It was my client's sister. There was a bilingual aspect to the whole relationship. And if anything, that certainly does not justify termination, that indefinite unfitness, because if it's just the passage of time, they were on that cusp. And with that—
Your time is up. Let me just see. I don't see any other questions. Thank you very much. Next, we're going to hear from the department, I believe. Mr. Fairbairn.
Good morning, Your Honors. I may please the Court. Robert Fairbairn on behalf of the Department of Children and Family. Your Honor, the trial court did not err when it found mother indefinitely unfit by weighing mother's 2 decades of polysubstance use, criminal history, and history of child neglect against her 2 years of progress and the child's need for permanency.
It's a tough one, though, right? Because they were making progress, and I don't know if they're listening on the live stream. There is no question in my mind that, and we hear DCF cases every sitting, these parents were trying, and I'm struggling with, and I know you're going to cite to me the case law that says the child shouldn't have to wait for permanency. I know that Child's Counsel has cited that, and that is correct. That is our law, but what are these parents supposed to do? What more could they have done?
But in terms of services, Your Honor, they were doing everything they needed to do. However, they had not advanced far enough in those services. The trial judge—
All right, my famous question, how much time? 6 months, 9 months, 13 months? What's the number?
I don't think there's a magic number, Your Honor. I think
Right.
it's contextual. And that's what the trial court did here, Your Honor. The trial court spent 20 findings of fact discussing all of mother's progress. They're extremely detailed. In the conclusions of law 4, 5, and 12, the court outlines its reasoning. The court carefully considered mother's history and father's history, both their past and their progress. And
Why terminate? Why not say, currently unfit, child stays with dad's sister, keep going?
Because the child, Your Honor, it's indefinite. We don't know when they're going to be done. When their treatment really reaches sort of a phase where they're self-dependent. Mother's experts said—
We know we want to free kiddos up for adoption, but this is a kinship placement. I look at that a little bit differently. This isn't putting the child on mayor.
It is a kinship placement, Your Honor, but it's still the child's bond with their caretaker. It's still the amount of time. Whether it's family or it's a stranger, the focus is on the child and their particular bond. And although kinship placements oftentimes lead to more amicable resolutions, but here that wasn't the case. Your Honor, the trial court, in examining the parents' past history, spent a great deal of time talking about the program, the nature of the program they're in. Mother testified, for example, the parents were progressing well, but in each program there were social workers available to them on call. They were in a structured environment. Mother, who testified that her mental health was key to her sobriety, her medication was dispensed and logged. So these parents hadn't reached a point of self-sufficiency, let alone being able—
And they weren't there.
And they were not there. They weren't there yet. Their progress is commendable by any metric. But however, the focus isn't on the parents. The focus is on the child and the child's needs.
So what's our closest case published or unpublished, on these facts, 2 years of sobriety, high structure circumstances that we said affirm termination? What's your best case?
I'm not sure that there is a case very similar to this. I'm sorry, Your Honor, I know there was a case where the parents had 2 years of sobriety, nearly 2 years of sobriety.
Okay. And am I right that at the time of trial, there were no open criminal cases?
No, Your Honor, both parents were on probation. By the time trial
No
concluded...
new charges?
No new
Okay.
charges. The parents began, their path to sobriety began in October 2022 after their arrest for trafficking.
And you make a point in your brief at page 25. You say, during the 2 years, this is as to Mom, that she had been abstinent for 1 year and 11 months at the conclusion of the trial in September of 2024. 8 of that, she was incarcerated, and of the remaining time, 3 months, she was in a residential treatment program responsible for her medication management and providing daily support. So that's 11 months out of 23 that she essentially was in a structured, what was happening the rest of the time?
Mother was in a treatment program from the moment she was released, Your Honor.
But was it a locked unit? I mean,
It
part
was,
of it,
it was not locked. It is a residential treatment program for substance use.
that she would have been bounced if she violated.
Yes, if she violated, she was drug tested multiple ways.
And at the time of trial, she was still in that program.
She was still successful in that program and was, the court noted, a model participant in hearings.
Has there been a R&R since?
I do not
I don't
believe,
want you to go outside the record, but could you just answer that,
I do not know if an R&R has been filed, Your Honor. I don't think they can pending the,
pending this? Okay.
Your Honor, finally, in reference to father, the court spent time focusing on father. When father was released from jail, there was an interim where he wasn't in therapy, he wasn't in a program. He did get himself in, and he was progressing, and both parents are doing well. However, Your Honor, in the context of the length of their histories and both struggling with substances and criminal behavior, Your Honor, and past history of child neglect, the trial court did not err in finding that the parents were currently unfit, and the termination was in the child's best interest. And unless there are further questions from the panel?
I see none. Thank you very much. Counsel for the child.
May it please the court, my name is Holly Armitage and I represent the child in this case. And we ask that this court affirm the termination of parental rights.
Don't go out too far outside the record. Is the child doing okay?
Yes.
Why don't mom and dad get a chance here, right? They did what they were supposed to do. I mean, we're not going to, the history is the history. We all know what the history is. 2 years, yes, highly structured.
Your Honor, I would beg to differ a little bit. The parents were in jail for a good chunk of that time, and they weren't being tested. So we don't really know what was happening for them. The father
Drugs
left
never
jail.
get into prisons. We know this, right? I'm
Yeah.
being sarcastic.
The father left jail just 5 months before trial began, and he didn't enter a program until 2 months after he left jail. So I would say
3-month gap.
yeah, so now mother was in a program outside of jail for 10 months before the trial began. Neither one of the parents were in a locked facility, but the mother's social worker did testify that it was essentially locked. Mother was on a GPS. Mother had a 1-year suspended sentence hanging over her head. Father was getting drug screens from probation. I agree that parents need guardrails. I think right before a child is returned to a parent, they shouldn't be reliant on guardrails that are as big as the guardrails were in this case. I respectfully disagree with, I believe it was father's counsel. these parents weren't living in an apartment yet. They were getting utilities hooked up. They were ready to leave their programs, but they were still in their programs when trial ended. So when trial ended, we don't know what happened. When they stepped out the door of those programs, they were both also still on probation until November. So both mother and father were still on probation, and mother had the suspended sentence.
24 or 25?
Of 24. So trial ended in September. They both had 2 months additional probation hanging over their heads.
Can you speak a bit to Dr. Bell's assessment of mother and how you think that plays into this?
I certainly can. Dr. Bell looked at mother not just as a parent and her relationship with her child, but also Dr. Bell did psychological testing to see, what kind of a person was mother and how was she functioning. Dr. Bell had concerns about mother in her behavior in parenting the child, but also stated in her testimony, and I believe in her report, that mother's long history of relapse and programs and relapse and programs didn't show her ability to take what she had learned in a program and bring it outside into the community with her to be successful in the community. And the judge then really relied on the same logic. I don't know that he relied on Dr. Bell, but I think the judge looked at the same sort of logic and explained that, these parents are in a situation of enforced abstinence. And if you look at the adoption of Surge, you also see a case where this court found that enforced sobriety is not enough to compel a finding that the parents will remain sober when they leave the program. And the court also found that the mother's 6-year pattern of drug abuse and persistent relapse was in the record, and the judge wasn't obligated to find that that would change. I think the judge in this case was quite torn. I mean, he did see the parents' progress, but he didn't just focus on the parents' substance abuse in concluding this case. The judge also looked at the parents' criminal records, their repeated incarcerations. He looked at mother's DCF history, which had the 4th child, the termination of parental rights, had only gone through in 2017. So it was a 5-year gap between that happening and this child being born, and the mother was still struggling with mental health issues and substance abuse issues when this child was born.
Do you think dad stands in a stronger position?
Well, I think the father in this case has the substance abuse issues, has the incarceration and criminal conduct issues. He also had significant parenting deficits. The father exhibited poor parenting skills at his visits with the child. He had difficulty engaging her. He was unsure what to do with her.
First child, though, right?
It's his first child.
We all make mistakes.
We do. But he needed redirection and assistance from DCF or mother, and mother testified at trial that this child was shy and uncomfortable with her father and really didn't know him. So I don't know how a father can parent a child who is uncomfortable with him and doesn't know him when that parent has also been unable to benefit from a parenting class. The only thing he was able to report that he took away from this parenting class is that you shouldn't be violent with children. So I would argue that both of these parents had significant deficits. Mother had mental health issues. She also had parenting deficits, which are pointed out by Dr. Bell. And she hadn't begun to seek real treatment. She was starting work with her 3rd therapist, and she had yet to tackle her mental health issues in therapy. I see that my time is almost up, and if there are no further questions, I would rest on my brief for the
I
remaining issues.
don't see any. Thank you very much. Obviously, all counsel, these are very difficult, heart-wrenching cases. We will take a very hard look at it and get our decision to you, but I do want to commend the parents for the efforts that they've made. Thank you all. Our next case, which I am sure to mispronounce, is Anthony IANNUCCILLO versus Mark IANNUCCILLO and others, 25P853. Counsel will tell me how to pronounce that.
Good morning, Your Honors.
Good morning.
May it please the Court, Brian Freeman on behalf of the appellant.
You're not going to tell me how to pronounce it?
I believe it's IANNUCCILLO, like you said, Your Honor. Your Honors, this case, the trial court decision in this case is inconsistent with established and controlling Massachusetts precedent, longstanding, concerning the rights of a survivor of a tenancy by the entirety to be immune from the personal obligations of their predeceased spouse. The trial court decision imposes a constructive trust upon the interest of the survivor based solely upon the unilateral actions of her predeceased spouse.
All right, what's your home run case that says that?
What the home run case that says that in terms of the constructive, just the tenants by the entirety law in and of itself says in a number of cases cited across the centuries, literally, alienation by either the husband or the wife will not defeat the right of the survivor to the entire estate on the death of the other. There can be no severance of such estate by the actor of either alone without the assent of the other.
Okay, so I apologize. I'm going to have a lot of questions, as I think the panel will, so.
Absolutely, Your Honor.
With us. If, and I know they're married, but if this property was held as tenants in common, same result? Or is it because it's T by E?
Well, if the property was held as tenants in common, hypothetically, which, you know, in my position, it was established as a TBE, but
Right,
to answer your hypothetical, I believe that at most you could find the constructive trust against father's percentage
So 50%.
interest. Yeah, if you want to say that the record established his promises bound the property.
All right, so go with that.
Yes.
Now, here's my next hypothetical. I know this isn't what happened in the case.
No, it's
but
okay.
I'm trying to understand it.
Absolutely, that's why we're here.
Mom and dad, tenants by the entirety, no one's passed away. There's some claim brought in some fashion for a constructive trust because Mark wants to establish this now before anyone passes away. Could he establish a constructive trust on 50% of the property held by mom and dad as T by E?
No.
Because it's held by T by E.
Because of the nature of the TBE,
Survivorship.
you don't take 50%, you actually own 100%.
So mom and dad, same hypothetical, but they own it as tenants in common, everyone's still alive. Mark could try to establish a constructive trust on dad's 50% in a tenancy in common.
Yes.
Okay.
If I could just expound on that, Your Honor, if they're both alive and it's in TBE, and Mark tries to bring the claim for a constructive trust, he can establish it, but it's subject to defeasance. If it's based upon the father's unilateral actions, there can be a constructive trust, but just like any debts of the father, if it matters who survives, and if he doesn't have mother's assent, which he clearly does not have mother's assent here, that it's subject to defeasance when mother survives.
Well, let's just say it's not quite so clear that there's no assent by the mother. Certainly, there's direct findings and findings that the agreement was with the father, right? And that
I'm sorry, Your Honor, I just missed.
the agreement was with the father. I mean, the facts as found by the judge emphasized that the agreement was with the father. But there's also facts the judge found that the mother, the donor here, was aware of the agreement, knew about the agreement, and that in terms of the family dynamics, other people knew as well about the agreement. So why does that not change things?
Sure, thank you. It's an excellent question. So, Your Honor, the standard for binding the non-promisor spouse in a tenants by the entirety to the promises of their spouse is assent. The legal standard is assent. And you see
And how does that look, what does that look like?
So that looks like, if you look at the case we cited in our brief, double B capital, this is a case where one of the spouses is taking, a TBE is taking out a mortgage. The debt is individual to that spouse. However, both spouses sign the mortgage itself. So the assent of the non-debtor spouse is there, and the rights are established in the creditor, because there's been an affirmative assent by the non-debtor spouse. But this is the crucial error by the trial court, is what you're getting at, Your Honor, is applying a knowledge standard when the case law is assent. And the case is incredibly clear that there's no assent by mother.
So when you say assent, what you're really looking for is something much clearer than, as you point out, knowledge or acquiescence.
I'm saying, yeah, something that she joins in the promise. She acknowledges and joins into the debt.
In the family dynamics here,
yes,
why wouldn't that also constitute assent?
So
it's not a creditor where you're signing your name. I mean, this is a little bit different. This is a little bit different, right?
Well, I'm just saying, I don't see how the family dynamics equal assent here, because it's really undisputed
could they
on
support? I'm not saying equal. I said, could those facts that the judge found
support assent?
Yes.
No, because the mother doesn't sign anything. She also, there's the defendant himself has sworn.
He didn't sign an agreement.
But the defendant himself has sworn testimony. His own trial admissions are that he never discussed this with mother. He says himself, this is an agreement with father, and it died with father.
He actually testified that the agreement died with his father when his father died.
Yeah.
I saw that. Yes, I see that. But that still doesn't really quite answer my question as to how much you need to establish assent under our case law.
Agreement in a court. I mean, I think the double B capital is the best case I have.
Let's say it was different. Let's say the mother had died first.
Mother dies first, sure.
The father then decides to put everything into a trust.
Yes.
And like with the same terms, just to the same terms, okay? And the judge determines that, well, there was this agreement, and that agreement is such that I'm going to establish a trust, a constructive trust here. Would that be a problem?
No, because it would be based on his own action. Should be imposing the constructive trust based on his own promises, not on mother's promises. Mother makes no promises.
So in your view, then, there has to be actual evidence, and of course the judge would have to find and credit the evidence of the mother's agreement. And not sufficient that she knew about it, agreed to it, assented to it.
No, she didn't assent to it.
That's what I'm trying to say.
Well, and in terms of, I don't think knowledge is sufficient, because the case law says assent. And I think just to give the example.
What case, I'm sorry, what specific case says the standard is assent, not knowledge?
So, a number of them, but just for example,
Give me the one
Bernatavisius versus Bernatavisius. This is the case that established that divorce terminated a TBE and created a tenancy in common.
Which case? Because you also said you cited some capital case, and I can't find that in your brief. So
Sure, that's double B Capital Group versus Ellis, Your Honor, 101 Mass Appellate Court 903.
that's not in your brief. I don't see it.
It's in the reply brief
Oh,
at page
okay,
10.
thank you.
I apologize, Your Honor. So that's
Sorry,
cited in that case.
so back to my question.
Sure.
I asked what's your best case that says assent is the standard, not knowledge? And you cited a case, but I didn't.
Yeah, so it's cited in number, Your Honor. So it's Raptis versus Pappas says it.
Raptis versus Pappas.
Also Bernatavisius versus Bernatavisius. You see identical phrasing about the TBE black letter law.
Do those cases also make clear that acquiescence does not equal assent? To get at Justice Vuono's question.
I think the case law just uses the assent, and I think assent is a legal standard. And I think there's a very difference between knowledge and assent. Knowledge just means I'm aware of something. Assent is I agree to it. This court could get in motion.
What I think Justice Vuono was asking, but if she wasn't, I'll ask it.
Sure.
Why is acquiescence not enough? What case or
I don't see that we
authorities?
have acquiescence. Yes, what I wanted to get to is,
Okay, but the question is, can acquiescence be enough?
I don't believe there's any case that supports that acquiescence is enough to defeat. The survivorship right in an tenancy by the entirety is very strong, said to be indestructible. And I don't know any case that suggests that just simple acquiescence without doing something affirmative to agree will destroy that right.
So Liquor says, quote, "There can be no severance of such estate by the act of either alone without the assent of the other." And that's that 1929 case. Are there cases that define what assent means in this context?
So I think the best example I have is Double B Capital, because they're saying, in that particular case, they're saying the critical act isn't that she's aware of the debt, but that she signs the note, she signs the
And
mortgage.
the mortgage solely taken out by the husband.
Yeah, they jointly sign the mortgage. The note is individual to the husband. So it's an individual debt that she's acknowledged and agreed to be bound. That's manifesting and agreed to be bound by it. What's that?
Judge Black found that the mother did not discuss the property with him. No one has claimed that that's a clearly erroneous finding. Therefore, that is tantamount to assent.
So I don't believe we have anything approaching assent by mother in this case, Your Honor.
To a lack of assent.
Yes, but I think separately, and we did address this in our brief. Even finding knowledge on the record, I think, was clear error by the judge, because the finding of knowledge, it's fact 232. There's exactly one fact out of 315 facts that address mom's knowledge here, and it's in the context of a conversation in 2017, 40 years later, between mom and her daughter about her estate planning documents. And there's nothing specific to this particular agreement or this property in that conversation. We highlighted it in footnote 6 of our brief. So even knowledge, we think, is clear error of law here.
Well, there were other facts from which one can infer knowledge.
I don't believe any by mother, Your
The
Honor.
mother was the accountant for the family. I mean, but you know,
I don't see how that would infer her with knowledge of this agreement, being the accountant of the family. I believe, what we're talking about is stripping someone of a very powerful right under the law.
What I'm getting to is, just knowledge. It's not a leap to infer that the mother, in this case, given the family situation, would have knowledge of what was going on with the properties. That's the point.
Could I just say, if we lower the standard on tenants by the entirety of being bound by your spouse's debts from assent, which it is, to knowledge, we've destroyed the protection. We've destroyed it. Because now all you have to do is have knowledge of your spouse's debts to be bound by them. I have a $10,000 credit card. Now my wife's bound by it. It would result in spouses intentionally concealing their debts from each other. So you would destroy the protection.
What could have been done here to secure the ownership
Mark,
of the property?
Thank you. It's an excellent question. Mark, the defendant, has absolute knowledge that mother is going to be a joint owner of the property. He needs to secure her assurance. When he doesn't secure her assurance, he proceeds at his peril. He has absolute knowledge she's going to be an owner of the property. He has no confirmation from her that she's going to be bound by this agreement whatsoever. So
you're saying he should have spoken up at the family meeting?
he should have spoken to mother even before title was taken. He's relying upon father to bind mother, and under the case law, father absolutely cannot bind mother. That is the whole tenants by the entirety
Even a
doctrine.
domineering partner can't do that, is your point?
Excuse me?
Even a domineering partner cannot bind the other tenant, is what you're saying.
Especially a domineering partner. Especially a domineering partner can't.
I want to ask you a question from a different perspective. So the imposition of a constructive trust is an equitable remedy. And we all learned in law school that if there's a remedy at law, we don't go to equity. So what was the remedy at law here that was available to Mark?
What was Mark's remedy at law, Your Honor? So I don't believe that you can get to the equitable remedy if the law precludes it. So I don't think you get to this.
That's what I'm asking you.
So I don't think you can get to the equitable remedy when the judge has.
That's what she's asking.
Asking you
She's
that.
asking, what is the legal remedy for Mark as opposed to the equitable remedy? What was the legal remedy?
I mean, he could have brought some sort of claim for breach of contract against the father, right? The agreement was to transfer the property.
Could he have filed a claim against the father's estate?
He could have filed a claim against the father's estate. The property wouldn't be in father's estate, but other assets would be.
Could he have filed a claim against mother's estate, not a constructive trust?
No, because he doesn't allege any wrongdoing by mother.
Well, let's back up a minute. Why couldn't he file a claim against the father's estate? He dies intestate. The Amesbury property goes to mother automatically under the provisions of the tenancy by entirety, right? But he still could have protested and said, actually, no.
Sure.
He would have had to argue that she had knowledge or whatever, but he would have had to have argued against that property going passing.
Sure, in theory, he could have done that, yes, I guess. I mean, he has 40 years to try to enforce the agreement.
But there is no legal remedy there because, according to your argument, because a tenancy by the entirety is the only.
Well, he has rights against the father. I mean, the father is the promisor. He has rights against the promisor, not against the innocent spouse.
Okay.
Thank you, Your Honors.
Actually, I know it's red, but before you sit down, there seems to be a difference of opinion, and you respond to it in your reply brief about what our standard of review is. You believe this is de novo because this is a legal question, correct?
Yeah, I believe it's a fundamental legal question. Can a constructive trust be imposed upon the survivor of a tenancy by the entirety based upon the actions of their predeceased spouse? I would say even if you somehow thought it was abuse of discretion, which my brother submits, the discretion does not exist to ignore the tenancy by the entirety law. That's binding law. So I think you get to the same result either way, but yeah, we submit it's de novo.
Thank you. I don't see any other questions. Thank you very much.
Thank you, Your Honors. Rest on our brief.
May it please the Court. My name is Andrew Caffrey, Jr., and I'm here representing the appellee, Mark IANNUCCILLO. And I have a very different view of this situation regarding the tenancy by the entirety. The appellant's practically entire appellate brief is based on the title to the property being held by the parents as tenants by the entirety. I suggest that this argument is a red herring and is irrelevant. As the appellant points out in great detail, Chapter 209 was adopted in 1980 to equalize the rights of spouses holding property as tenants by the entirety so that each is secure against the impairment of rights through the sole act of the other. There can be no severance of such estate by the act of either alone with the assent of the other. The survivor becomes a sole owner, as happened in this case. In this case, however, there is no allegation that the father did anything to sever the estate unilaterally once the tenancy was established. With the recording of the deed, it became a tenancy by the entirety. Subsequent to that, what did the father do to sever the mother's interest? Nothing. The other thing is that most of the case—
How does that help you?
How does that help?
Because the constructive trust was established between Mark and his father when Mark found the property, negotiated the price, talked to his uncle, then brought his father in, and his father, in his domineering manner, took over the matter. When the tenancy by the entirety, the father did nothing during the tenancy. All the cases cited talk about something the father did where he borrowed money or he did something else during the tenancy. The other significant thing is that is limited. The tenancy by the entirety protection for spouses is limited if it is their principal residence. And this was not their principal residence. If you go to—
And what authority says that?
Chapter 209, the second paragraph, Section 1, the second paragraph, limits that protection against creditors to where it's the principal residence. But again, we're not dealing with contractual matters here. We're dealing with matters in equity.
But are we, if we have title to a property that's held as tenants by entirety, what is the authority to impose a constructive trust on mother?
The inequity, because as the court findings were that the mother knew about this, she was the family accountant.
Did Judge Black find that she assented to it?
She was complicit in knowing that it was Mark's house and it was
She
supposed—
assent to it? Did the judge find she assented to it?
I don't believe the judge used the word assent.
And don't our cases say, starting in 1929, that assent is the key?
Again, that happens with something during the tenancy where a mortgage is taken out or something, and that's not the case we have here. Mark and his father, fiduciary relationship, established a constructive trust. He gave him the money, the property was bought, and he said it's going to be put in your mother's name and mine. There was no discussion about the type of tenancy. Mark wouldn't know from anything whether it was joint tenants by the entirety, or anything. There was no discussion in saying, oh, okay, well, if you're going to do it by tenants by the entirety, then I guess I better get my mother's assent. This was a trust, a relationship of trust between Mark and his father, who was, as we understand it, domineering.
She opposes the constructive trust on mother. It was, to your point, you just said father and Mark were in a fiduciary relationship. So if Dad hadn't passed, the constructive trust was as between Dad and son, no?
Correct, and the mother stepped into that through the actions of the father and through the
All right, you're going to have to explain that to me, and what case says that she stepped into that?
Well, let me get, I mean, as I said, there was no discussion about the type of tenancy, and I don't think
No, I want to know how mother stepped into that.
Okay. I would say notably the appellant does not cite any Massachusetts cases supporting its position that the court's determination was erroneous. It does, however, point to a Missouri case, U.S. Fidelity, 670 Southwest 2nd, 134. In a badly reasoned attempt to support its position that a constructive trust cannot be imposed where there is no wrongdoing by one of the spouses. On page 24 of its brief, appellant says, the Missouri Court of Appeals held that one spouse's embezzlement was insufficient to impose a constructive trust upon property held as tenants by the entirety. If you read that case, however, in fact, what the court stated is, quote, it is undisputed that the embezzlement by Marion Hiles is a sufficient wrongful act to give rise to a constructive trust. The dispute is whether the plaintiffs met its burden in tracing the embezzled money into the real estate in question. So in that case, even though the spouse of Marion had no part in the embezzlement, the Missouri Court of Appeals, as pointed out by my brother, was ready to impose a constructive trust over the property.
Good news is, there's a lot of family dysfunction here. I haven't read about embezzlement, so I'm going to give one good news for this family. I still want to go back to, how did mother step into father's shoes in this case?
Because the father was the domineering party in the family that was enmeshed. Mark and his father worked out an arrangement, or entered into the constructive trust, and the father, in his domineering manner, said it's going to be put in your mother's name and mine for now, and at some point it will be deeded back to you.
That would work, except that Mark himself testifies.
I'm sorry?
Mark himself testifies. Well, first of all, a couple of things. The judge makes findings and describes the father as domineering. The mother the judge also describes the family dynamics as enmeshed, et cetera, but never actually says that as a result of that, mother knew what was going on and either acquiesced or had knowledge, or let alone assented. So that's one issue. But even more importantly is Mark himself testifies that he did not discuss it with his mother, does not ever say his mother knew about this. To the contrary, he said that the agreement died with his father, right?
Yes.
Okay, so then how do you get to your point?
Well, there was sufficient evidence, and as was found by the trial court, that the mother was aware and was complicit. Yeah. She never said, Mark, I'm going to deed the house to you, I'm going to leave it to you in my will. There's nothing along those lines. But the family referred to it as Mark's house. The mother knew what was going on. There was the family meeting when Mark was pressing the issue, and she said, don't badger your father. And, the trial court found...
Did mother have to do that during father's lifetime?
I'm sorry?
Did mother have to do that to make any objection known during father's lifetime?
I don't know that it had to be during the lifetime, or it could have been subsequent, but it was during the father's lifetime.
Right, but then subsequently she puts the property into I'm not following, she puts it into a revocable trust.
And includes
the benefit of everyone. Why isn't that doing exactly what you said? Why isn't that stating, I own the property, I'm doing something different with it as a matter of law?
That's what she tried to do, or that's what she did. But again, we're dealing in equity here.
Okay.
And the court, found that the court has wide discretion.
Sure. Let me ask you this. So you don't dispute that, let's start with the fundamental principle. You don't dispute that mother properly owned the property because of her right or survivorship as a tenant by the entirety after father died, right?
Correct, until this claim was placed.
So one of the elements that your client needed to establish here is unjust enrichment, correct?
Correct.
How was mother unjustly enriched then when the property rightfully went to her? It seems to me you're almost arguing that it's the other children who would be unjustly enriched as opposed to mother.
Well, no, the mother had really no equitable interest in the property, having it.
She had a legal interest in the property.
owned it.
A legal interest, right.
So how does the equitable interest somehow trump the legal interest? That's what I'm not seeing.
No, she had no equitable interest.
Right.
Because this was Mark's house. Mark had paid the money. He had done what his father told him to do. The constructive trust had been established back in 1978, and it can't be revoked or amended even though the father changed his mind. We don't know what happened. We do know that there was testimony that the father said he changed his mind. There was also testimony that when the father was thinking out loud about what to do with his properties and his children, that he discussed the Salisbury Beach property and how to split that up. He discussed the Larchmont property and how to split that up. But he never discussed Amesbury and how to split that up, again, as further evidence.
Yes, he did. 1/3, 1/3, and 1/3.
Right. But up until that point, he had never discussed that. What the judge took away was because he determined that to be Mark's property. Now, in 2012, there was this meeting, and he made that discussion. He had changed his mind. Who knows why? But, up until that point. And so the mother really had no equitable interest, in my mind, in this property. She had legal title because of the tenancies and stuff. But for her to have control over the entire value of Amesbury is what is unjust enrichment. I mean, whether she gave it away to charity or whether she gave it away to one child or whoever, she really should have had nothing to do with that.
Doesn't that render her legal interest in the house illusory?
I'm sorry?
Doesn't that render her legal interest in the home illusory? If you're saying...
I'm missing the last, to what?
Illusory.
No, I don't think so. I think that, this was something she ended up with. She knew that the court finds that she knew what the arrangement was, that it was Mark's house.
Where does the court actually find that? That she knew what the arrangement was?
Because the findings talked about her being the accountant. It talked about her referring to the house as Mark's house. I mean, the obvious...
And does that support a finding that she knew about the agreement?
Yes. Well, she knew that it was Mark's house.
Let me ask this question slightly differently. In 2012, when the father says, this is what I'm going to do, 1/3, 1/3, 1/3, mother's sitting there and Mark is sitting there, right?
Yes.
Mark doesn't say anything. Mother doesn't say anything. So how does that affect mother's, well, it doesn't affect her legal right because she's a joint survivor, but how does that affect what you're referring to as her equitable right?
It was a subsequent meeting, or right after that, with Mark and Betsy and the parents. And Mark started to say, why didn't you tell them what our arrangement is? And the mother says, don't badger your father, leave him
and
alone.
he stares out into space, so yeah.
Right, and he didn't answer it.
All right.
So I think it,
And that amounts to, in your view, the mother's not just knowledge, but assent to this agreement.
No, I would agree that she never assented,
Okay.
but she was complicit, she knew about it, and she let it go. And again, I think, the big
So
thing
let's
is...
just say, for example, the embezzling example. The chief has wisely said that we don't have that here in this case, but so if the father had been embezzling, right, and the mother knew about it, then you would say, well, then she's responsible. She's complicit in this criminal conduct. So therefore, if a creditor comes along, creditor gets the whole property, correct? Is that what you're saying?
Well, the Missouri court didn't talk about whether she knew about the embezzlement, but said she was not the embezzler, and they were willing to enforce a constructive trust on her interest. I mean, the other thing is that if this was, again, the tenancy is a red herring, I think. It was not raised at the trial court. That's why the court doesn't discuss the joint tenancy issue, because it wasn't raised. So it was.
She does.
What's that?
She does.
She identifies the deed as being a tenancy by the entirety, but she doesn't discuss any implication about that. I would suggest that if the mother and father owned this as joint tenants, we would be in the same place, because the mother would have inherited it. And it doesn't matter. The tenancy doesn't matter. What if it was a joint tenancy? She still inherits it, and we still have a claim for a constructive trust.
And with all of the argument and question you just heard, you still think the appeal is frivolous?
Well, yes, in part because he's raised an issue that was not raised in the trial court, and that's what he's based this whole thing on, this tenancy by the entirety. And again, I just don't.
You didn't cross appeal, right? Because the judge made findings about the tenancy by the entirety. You didn't cross appeal on that.
No, but when you say findings, she simply found that the deed went into the parents as tenants by the entirety. I don't think you find.
Isn't that a finding?
Yes, and it's true. But it was not an issue as to what the significance was that was raised down below.
This is just not a good solution for anybody, no matter what happens in this case, right?
I'm sorry?
This is not going to be a good solution for any of the parties in this case, this family.
Well, I think it should be a good decision. The appeal should be defeated, and it should be a constructive trust for the benefit of my client, who lived there all those years and treated it as his house and thought it was his house.
Thank you.
Thank
Case
you.
is under advisement. Well argued. Our final case of the day is NOELLEN Bouquet, I'm sorry if I mispronounced that, versus Commerce Insurance Company, 25P1008. And we always like to end on an insurance case. It gets us ready to go.
Sure it does.
I'm sorry if I've mispronounced your client's name.
Oh, it's okay. Chief Justice, members of the panel, may it please the court, my name is Paul Franco. I represent the plaintiff, of the appellant, Noëllen Bousquet. French Act.
Can I ask a preliminary question?
Yes.
So you frame this as, I believe, instead of trial, you say the parties agreed to submit their respective positions by brief.
Yes.
The docket refers to this as a bench trial, and the appellee refers to this as a bench trial.
You mean at the district court level?
Yeah. So there seems to be a dispute, and so I guess what I'm at, do you agree that there was basically a stipulated trial or a trial submitted on the pleadings, but that it was indeed a trial?
Yes, yes, I would agree with that, Your Honor, because
that's
it was, we submitted requests for findings and everything like we would in the normal court. The key issue of this case is whether the Division of Insurance can place conditions upon the receipt of MedPay benefits under General Laws, Chapter 175, Section 113C. The short answer is no. The enabling statute does not contain any language placing conditions upon receipt of MedPay coverage. The statute allows for the insurer to issue MedPay coverage in the amounts of $5,000 as a minimum coverage. Even the legislative history, which is on page 32 of the addendum, does not contain any language or provisions allowing for the placement of conditions upon the receipt of such coverage. The SJC has ruled that the policy language should be read in accordance with the statute's, purpose and history. But we, that's courts, are deferential to the commissioner, that'd be the Commissioner of Insurance, interpretation, so long as it is reasonably related to the objective of and or within the ambit of the enabling statute. That's that Arbella Mutual case, which I cite on page 10 of my appellate brief.
So are you still relying on the, I don't know if it's Golkin or Golchin case?
Well, the way Golshin and all those other cases, the reason why the Division of Insurance changed those, implemented the changes, is to overturn the appellate courts.
Why can't they do that?
Because they cannot do it if it's contrary to the statute and it doesn't fall within the ambit of what the enabling statute provides.
I agree with that. So the SJC in Golchin says at page 166, that being said, Liberty Mutual's concern about duplicative payments may be warranted. Indeed, and then they go on and explain that it seems probable that MedPay is a benefit that may be approaching irrelevance in light of the recently enacted universal health care mandate.
Right.
And then the court goes on to say this, page 166 and 167.
Yep. Yes, sir.
Liberty Mutual, however, is not without a remedy. It is always open to automobile insurers to petition the Division of Insurance to change the language of the policy so as to clarify that it does not require the result of which they complain. It seems to me that's what happened here.
That affords them the...
Why would the SJC be saying that if there needed to be a statutory remedy, as you're arguing here?
I don't believe the statutory remedy was even addressed at in that court decision.
It's saying there doesn't need to be a statutory remedy. It said go petition the Division of Insurance to change the language of the policy so as to clarify that it does not require the result of which they complain, i.e. the duplicative payments.
Right. And again, I would respectfully disagree because the issue of whether
Disagree
or not...
with what? Disagree with what the SJC said?
Well, no, because the SJC never actually determined whether or not the policy language would afford that particular change. Because the change that was enacted under Part 6 of the MedPay coverage basically rendered MedPay coverage a nullity under the existing law. If all of us are required to have health insurance in any form, whether it be public or private, we can never get to use the MedPay coverage. And in this case...
Yes, you can, in certain circumstances. Co-pays, deductibles. I mean, deductibles now for many people are really through the roof.
No, the deductibles will come under PIP. They wouldn't come under necessarily MedPay.
Okay. Co-pays.
No, same thing, same thing. But that still doesn't provide adequate coverage for MedPay.
But there's all different kinds of health care coverages. Let's assume that the health care coverage in an accident covered, there's $500,000 worth of medical bills, and it covered $380,000. Isn't that a case in which the MedPay would kick in after the health care amount had been...
Let me answer that in using the facts in this case. NOELLEN BOUSQUET incurred over $18,000 in medical expenses. She had paid for private health insurance, she paid for PIP coverage, and she paid for MedPay coverage. And ironically, she had to pay the premium to get the health insurance. None of that coverage, except for $2,200 in PIP, was ever paid because she still owed the money to the health insurer on their lien. So in other words, it's still an expense that she had to incur, a medical expense, which we as her legal representatives tried to get Commerce to pay at least the lien. But they
wouldn't that be, if there was no lien and MedPay covered, why wouldn't that be a duplicative payment?
It's not because what happens is that ultimately when she resolves her third-party claim, she has to address the MedPay lien. She has to pay that back. And that's coverage that she paid for. If she wasn't involved in a car accident, simply fell at her house and had the same expenses, they would not, this wouldn't even be applicable. But she paid for the extra coverage. She paid for MedPay. And here's a perfect example of having coverage that she can't use. And in a situation where she should have been able to use this. And again, I point out in the brief that she suffers a loss of the benefit of that coverage because ultimately she has to repay back the lien to Fallon, and we got it reduced, obviously, so that she could get some money for her pain and suffering, but she still had to incur the expense, and I believe the Goldstein Court talked about the definition of expense. It doesn't have to be something that's paid for, it has to be something that's incurred. She incurred that expense.
Is this case somewhat of a one-off in terms of timing? Is this an ongoing issue? I know you say that what the division did doesn't help your case, but going forward, this isn't an issue anymore, right?
Oh, no, it still is. None of you, if you have the same type of health insurance you have for other government employees, are never going to be able to use the MedPay coverage. Myself, I'm never going to be able to use that MedPay coverage. I would love to use it. It's a great deal. It provides coverage. If it was paid in this particular situation, it would definitely have proved Noellen's position. But no, she has, it's to me, is the ironic part, is she has all this coverage and can't use it. And that's where I think the appeals court can remedy a tremendous flaw in the system, because it's hurting consumers like Noellen Bousquet and like the rest of us who would like to have the opportunity.
I understand that they can't use it here. I'm having difficulty with your proposition that MedPay is illusory and can never be used in any case involving an injury. Again, sometimes health insurance, it depends on what type of policy you have, what type of coverage. Sometimes it covers everything, sometimes it covers a portion, sometimes it covers a lower percentage. Aren't there scenarios in which MedPay coverage would be available once the health care insurance is exhausted on a case? You're telling me there's no case in which that would happen?
Well, think about that, Your Honor. You said once health care is exhausted. In this case, health care was exhausted, and she couldn't use it to pay back or to lower the lien. So, and again, I look at the language and the Record Appendix 101 talks about the specific language. And it says here, no payments will be made under part that duplicate payments made for the same bodily injuries. It talks about parts 1, 2, 3, 5, and 12 of the policy. In addition, no payments will be made under this part that duplicate payments made for the same bodily injuries under any other auto insurance or under health insurance policy covering the injured person. Well, that's everything. That could include not only, Blue Cross Blue Shield and Harvard Pilgrim, it could also include Mass Health, medical pay, MedPay. Medicare. So when you have that much language, all right, and you apply it to a situation like Noellen Bousquet, who was simply, she had suffered a horrific accident. She was 6 months pregnant. She got taken by ambulance to 2 different hospitals. They worried about her being in premature labor. I mean, this is a horrific accident, and she ends up having to pay back her health insurer for coverage that she already paid for. And again, Your Honor, I see where we're going, but I went back to
Not where I'm going, it's what I'm trying to figure out, what we're trying to figure out. We're not going anywhere.
And I think...
So let me ask you this question. You ask in your prayer for relief that Fallon should pay the entire, well, let me ask this. Fallon did initially pay the $16,740, correct? Right. And then they ultimately agreed to reduce the lien amount to $8,333, correct? You negotiated that.
That's what we had to negotiate.
So when you say in your prayer for relief that Fallon should pay you, or rather you should be paid, awarded $16,740, you really mean you should be paid $16,740 minus the $8,333, right?
Well, no, because that's money that's out of her pocket. In other words, if you go, to me, again, I'm trying to, if you go back to the statute and it says, this is your MedPay coverage, $5,000, no questions. Remember, this is first-party coverage. You're paying for that extra coverage so that in the event, the scenario that occurs like the Noellen Bousquet, you're going to have that coverage. But the Division of Insurance is saying, no, because you have private health insurance or health insurance that paid these bills, you don't get the benefit of that coverage. And they're trying to say that it prevents duplicate payments. It's not duplicate payments. It's additional coverage, first-party coverage. And that's something that we all are accustomed to in all aspects of our life. And again, this court has a remedy available to make MedPay benefits worthwhile. Otherwise, it's simply a way for the insurance companies to provide the coverage, charge a premium, and not have to pay. And I think that's not what it's designed. And if you looked at the legislative history and the language, the clear and unambiguous language of the statute, there should not, the Division of Insurance should not be essentially allowing insurance companies to fleece consumers. All right? Because in this case, NOELLEN BOUSQUET suffered a monetary loss because of the way this policy language was worded. And that's the bottom line.
So let me ask you this.
Yes, Your Honor.
So Fallon paid the $16,700. Had your client not brought the third-party tortfeasor,
right,
third-party action against the tortfeasor, against whom could Fallon have put the lien?
They couldn't go after anyone. I mean, technically, they could initiate their own subrogation action, okay? But it's again, if NOELLEN had these expenses, just say she fell off a chair at the house, same treatment, same whatever. If she doesn't have a third-party claim, there is no triggering of any coverage. There's no MedPay coverage for that amount. So
Also be also no duplicative payment.
What's that, Your?
There'd also be no duplicative payment.
Right, exactly. But in this particular case, it's ironic that she has to pay the premium for Fallon and then has to pay Fallon back for what they paid, and she can't use this additional coverage.
It's
Again,
because, as Justice Neyman's pointing out, because she has suing and received a settlement or money from another
third party. Yes. And that's what the gentleman that caused the accident only had $25,000 worth of coverage. They paid the policy, but the lien had to be addressed. And again, you'll see in the record, I asked the company if they could just pay the lien. Okay, at that time it was like $13,000, and they said no. And I'm like, all right, well, what am I supposed to do? You go and you look at the policy language and say they should pay it all right. That's coverage that all of us as consumers of the motor vehicle accident, of a motor vehicle policy in our state, we're entitled to that because we pay extra. But in this case and in any other case, there's no coverage. Okay, it's a superfluous piece of premium that, like I said, no one I can recognize can use. And again,
But it's not mandatory, correct?
That's right. That's optional, but it's optional coverage. But the
optional.
statute's still there. I would, like I said, and remember, the consumers can't negotiate the terms of the policy.
But you could choose not to take it.
Right. That's all you can do.
You
You
could
choose
say,
not to
I
take
don't
it.
need that.
Right. Well, yeah. Otherwise, you're paying for nothing, and that's the bottom line.
And
Anyway,
we will leave it there, counsel. Thank you very much.
Thank you very much.
Good afternoon. May it please the Court, Jody Connors for Commerce Insurance Company. And Justice Neyman, I did want to answer your question that you did ask my brother before or at the beginning of his
Get to the
oral argument.
microphone so I can hear
Sure.
you, please.
Justice Neyman, I did want to address the question you asked my brother at the beginning of his argument pertaining to the trial. And I will note, a review of the court docket indicates there was a trial scheduled for April 26, 2023 at 9 a.m. We did appear there that day ready for trial. We did meet with Judge Hadid, and at that time the parties agreed to submit the matter on the paperwork for Judge Hadid to review, which is why
And your brother agrees that this is it's tantamount to a bench trial, and that's what you referenced it as your brief,
I
correct?
believe it's a motion for judgment on the pleadings, as addressed by the appellate division decision. Initially, Commerce submitted its paperwork in response to Judge Hadid's order on June 2nd, 2023, which was in accordance...
I'm just saying that because in your statement of the case, you said they affirmed the judgment following a bench trial, but now you want to treat it as, does it matter whether this was a bench trial or with the
I
judge's
do not
findings?
think so, Your Honor. However, I did have the docket in front of me, and I wanted to address your question.
Okay, thank you.
Thank you. The question in front of this court today, or the issue in front of this court today, is whether or not there was an error in the trial court's finding and subsequently appellate division finding that an insurance company, particularly Commerce Insurance Company, in the state of Massachusetts can decline to issue payment for a health insurance lien under the 2016 Standard Massachusetts Automobile Insurance Policy, MedPay benefits, that was issued to Ms. NOELLEN BOUSQUET. That policy was renewed through her agent, McCrellis and Kemp. At the time the policy was approved through her agent, that policy was already approved by the Commissioner of Insurance. That policy issued a notice to the policyholders, which was approved, as well as an endorsement, which was approved by the Commissioner of Insurance. The notice delineated the changes to the 2016 policy from the 2008 policy, which included changes to the MedPay portion of the optional coverage portion purchased by Ms. Bousquet. Ms. Bousquet purchased $25,000 in MedPay coverage for a premium of $66. The $66 premium, as delineated in the notice to the policyholder, stated that MedPay benefits would be available for funeral expenses, for any co-pays or deductibles not payable under MedPay after the initial $2,000 in PIP benefits have been exhausted, for services not sought in accordance with a health insurance plan, or other services that are not covered by health insurance, meaning $2,000 in PIP benefits would be paid. Thereafter, any additional patient responsibilities, co-pays, deductibles, et cetera, the items I just listed would therefore then become due and payable under
So we know what happened here. Let's get to the meat. Two questions that I have. The first one is, explain to me with particularity, explain to us with particularity, how MedPay coverage is not now illusory.
It's not illusory because it provides for coverage. It provides for coverage, as I just indicated, for funeral expenses and for other medical expenses. The language of the MedPay policy basically is plainly and definitely expressed. And when language of a policy is plainly and definitely expressed.
Give me an example of a case in which MedPay benefits would be paid out to the consumer.
Well, the first one, which is the obvious one, if I was in a car crash and I passed, my funeral expenses would be paid. Second example would be I have health insurance.
And do it in a scenario where you as the consumer have health care insurance.
Sure. So I'm a consumer, I have health insurance. If I'm in an auto accident, my insurance company would pay the first $2,000 in available PIP benefits because I have private health insurance. Thereafter, there's an obligation to coordinate benefits with the health insurance company. I coordinate benefits with the health insurance company. They come back and say, hey, you have a $1,600 deductible on your policy. You have to meet that before we pay anything. I would turn around and submit that bill for my deductible to my insurance carrier, who would then issue, if I have optional MedPay coverage, which I'm assuming I do, for $25,000.
And that wouldn't fall under PIP? Let's assume you had $8,000 in PIP.
Not based upon the 2016 policy. No, it would not. Based upon the 2008 policy, when Met versus Blue Cross Blue Shield, strike that, Blue Cross Blue Shield versus Met was decided, that would have been the application prior to the changing of the policy language.
So let's say, again, we're post-2016 now, you took out $25,000 in MedPay benefits. Give me a scenario in which that would be paid out to you. Let's say $22,000 of that would be paid to you.
MedPay benefits would be payable for, so let's say I get a CAT scan, and I get it at a non-covered service provider. So let's say I go, my health insurance, I have to go to particular providers, which I'm sure some people's health insurance has that same provision. If I go get a CAT scan at a particular facility after my initial ER visit or after my initial ambulance transport, that's going to be over $2,000. If that CT scan is provided at a facility that does not provide for covered services and the bill's $5,000, that would be paid under MedPay.
And you guys wouldn't fight that. Your commerce would say, you learn that this person could have gotten a CAT scan from a covered provider, but you as the consumer chose to go to someone out of network. You commerce would say, well, we're going to pay it out of MedPay, or would you say, no, go to someone in network?
I can't speak for all of commerce. I know the strictly is MedPay. If we were dealing with PIP, the question you were asking.
Just answer my question with respect to MedPay. So again,
No.
they go to someone out of network.
No, it does no.
And you would say, yep,
There's no
it's MedPay, so we're going to pay for it.
I apologize for interrupting. There is no exclusion under MedPay for out-of-network treatment. The clear language of the policy says we will pay necessary medical and funeral expenses.
That would not happen if there was another tortfeasor, right? So this all works as all of Justice Neyman's questions. And you say these issues, that these particular bills will be paid under the Medicare provision, but only if the consumer has not sued the person responsible for the accident.
Well, that only pertains to the lien portion, but yes. So, for example, when the change...
Just the lien portion, let's say there's this $5,000 MRI out there.
Right.
And that was part of the lien, right? And that would then not come out of the MedPay. Is that correct? I mean,
It would not be payable as a lien, no.
Right.
A health insurance lien would be a duplicate payment. So in the scenario that I gave, it wasn't paid by the health insurance because it was out of network. So what I'm saying is that would be paid under the MedPay. But the two changes to the MedPay as a result of the 2016 policy would be that no payments would be issued under PIP if there was MedPay after 2K was paid, and that no payment would be made issuing or representing duplicate payments under various portions of the policy, which included PIP, MedPay, BI, and underinsured.
help me out with a scenario with the funeral expenses, for example, all right? Because people don't usually have insurance for that. That could be upwards of $20,000 potentially, right? So unfortunately, there's a fatal accident. The person dies. The family incurs funeral expenses of $15,000, hypothetically, and that also have a pending litigation against the person responsible. As part of the damages from that lawsuit, they receive money for the funeral expenses. They're not going to get it now from the insurance policy?
I don't think funeral companies, excuse me if I don't understand the question, but I don't think a funeral company would assert a lien and it wouldn't be a duplicate payment under the health insurance or other provisions.
Okay, so the funeral company does not assert a lien.
Correct.
Okay, but Commerce knows that the consumer has just received $15,000 in damages via settlement or wherever you want. Are they going to try and not pay that funeral? In other words, the consumer could potentially get that payment twice, once from the tortfeasor and once from the MedPay. And you're saying they would get that?
Based upon the plain language of the portion of the policy, what it says is that...
Well, in my scenario, would they receive that or no?
I've never had that situation in my 29 years of practicing insurance defense. I've never had anybody submit anything from a health insurance carrier, so I have not articulated that. I have not briefed that. If you want to go off off the cusp of what I can tell you is
I'm just trying to follow through when you said that one of the benefits from choosing this particular coverage is that it covers, for example, funeral benefits.
How would Commerce find out that it was paid through a tort foreseer unless their attorney came and told them?
I can't answer that question. That's why I'm asking you the question.
I don't think an insurance carrier in that situation, and it wouldn't be my legal advice in that situation to deny a claim. Commerce would not have the ability to ascertain, number one, unless there's a detailed verdict slip that says what amount of damage is delineated.
And is that because it doesn't fall into the category of coordination of benefits, which is different than this other?
Yes, Your Honor, because the CMR 211, CMR 38.05 deals with the coordination of benefits under what is determined to be a health insurance plan. And both PIP and MedPay, in accordance with 211 CMR 38.05 A1B, determines that both health insurance, MedPay, and PIP are health insurance plans which are governed by the provisions of the 211 CMR 3805, meaning that you are correct that funeral expenses would fall outside of the realm of the coordination of benefits, and thank you for completing that for me, Your Honor.
How would the payment here be duplicative in the case we have at hand?
Because the MedPay benefits are payable to the insured and other household members, so it would be payable to the insured. The insured was paid, or strike that, the insured health insurance company paid the medical bills at issue in this litigation, which included some of the bills to St. Vincent, which were paid to exhaust the 2K. Which is probably why it was negotiated. But in any event, could you repeat the question? I got out of my own...
You put in your brief here, among other things, you wrote that part of the reason for the appellate division's decision was to avoid duplicative payments.
Yes.
How would the payments here be duplicative?
because in accordance with the 211 CMR 38 and the terms of the policy, the payment of a health insurance lien is a payment by a health insurance company. A payment by a health insurance company was already paid by a party defined by 211 CMR 38.05. So it's a duplicate payment. It's a payment by a health insurance company. Its provisions, 211 CMR 38.05, prohibit payment by an insurance company for payment that's already been made by a health insurance company. So that's a payment which is prohibited pursuant to the 211 CMR.
So I think Mr. Franco's point, though, is if the person who was injured attempts to assert their rights and file a lawsuit against the tortfeasor, the bottom line is, under the scheme as currently interpreted, it violates at least the intent of the statute because any recovery is going to be reduced by the amount that the healthcare insurer already paid.
Well, the intent of the statute, Your Honor,
And,
the
and
MedPay
I
statute-
suppose, well, I suppose, well, go ahead.
Sorry. The MedPay statute itself simply states that an insurance company in the state of Massachusetts must provide MedPay benefits at the insured's option in the amount of at least $5,000. The purpose behind 175, Chapter 175, was to regulate insurance premiums and risks in the state of Massachusetts to prevent against discriminatory conduct and discriminatory premiums. Sure. And that is what the provisions of the MedPay, or the whole Chapter 175 of the insurance company CMRs are for, to prohibit expensive costs for premiums to prevent some type of discrimination in application of premiums. So the statute itself does not say anything about that. The statute itself has nothing about intent. The only intent that it basically, and that's why I cited earlier, there's case law that states that if the provisions of the statute are clear and unambiguous, then it must be strictly construed, meaning that what that statute says is an insurance company must provide MedPay, which Commerce did in this case. They provided MedPay benefits, and it must be in the amount of at least $5,000, which is what Commerce did. So there's no other language in the statute that pertains to liens. What pertains to liens is 211 CMR 38 and the standard mass auto policy.
So it sounds like what you're ultimately saying to Mr. Franco is any remedy he wants he has to ask the legislature.
I think that's what the court addressed in Blue Cross Blue Shield, yes.
I'm all set.
I don't see any additional questions. I'm happy to take the rest of the arguments on your brief.
The rest of my brief.
Thank you very much, Counsel. The case is under advisement.
Well argued.
That will end today's sitting of the Appeals Court. I would like to thank our court staff, particularly our court officers, our clerk's office, our fantastic timekeeper, and our law clerks. We are in recess.